Good morning to you all.
Good morning, Lordship. May I please, Lordship? Lordship, I beg to mention item number 10. This matter may be taken up day after tomorrow, Lordship. Supplementary hearing.
10
Yes, Lord.
is 2018 matter.
Yes, day after tomorrow,
It's
Lord.
only pay scale revision. Hardly it will take anything.
Lordship.
It's only a matter of pay scale revision.
Yes, Lord.
LDC.
Lordship, I returned this morning only, so I need some.
Has also
I
come
was
to-
Few tabs. Day after tomorrow, Lord.
I am here from yesterday, but my Lord has come today morning. That's at 7 o'clock.
Day after tomorrow, 22.
Okay.
Obliged, Lord.
Take it on the pair system.
Mayor, Lordship,
20.
Lordship, I beg to mention item number 2.
Item number 2.
Item number 2, my Lord, conducting counsel, Mr. Naveen Kumar is out state counsel, so he cannot represent today here for some personal difficulties.
Notice issue. AG appeared. The notice issue हो चुका है. Notice okay. Send 8 to the
In this item number 2, what is the stand of the government?
Because it's item number 2. That is AG hearing, and he has.
No, it's okay, but what is the stand taken here? You are only saying that the act is amended, so it is of the central government. It's not possible for you. Okay.
Wait.
Yeah, page.
So he has requested him.
Both sides are represented on the prayer made by
Lordship.
John today, list after
18 June.
18
Six.
June. Astrologically, not a good day. You consulted astrologer now.
And AG is requested.
Okay, 18 June.
Much obliged.
Okay.
State level also, right?
May I please, Lordship?
Just a moment.
May I please?
Just a moment.
Admit. I don't have a shot.
Okay, admission will have.
That's admission. Not actually we will last night. But case has been admitted.
What has happened to another writ petition 297? What has happened there?
There is put to challenge by this writ appeal.
But there is a. Affidavit by. From the date of vacancy. From the date of vacancy. 2011. Page 5. So अभी इन्होंने retrospective again take लिया। Determine किया। Similar issue में आपने page 63. That is a single one.
Yes, Lordship.
In terms of the order of this honorable court, madam, we filed the counter affidavit in manner.
From the date of adopt promotion, from the date of adopt promotion, you can't be entitled to regular promotion. It has to be from the day when the vacancies are available.
Yes, yes, madam. My lord, that has been identified by the DPC itself, my lord. And DPC was never questioned by anyone, my lord.
Have you seen the affidavit now?
My lord, just now he has told me, my lord, I have not received the copy also, my lord. So, my lord, he is providing me a copy today, my lord. So,
My lord, in fact, the vital question before the learned single judge, whether these petitioners, writ petitioners were under the 50% promotional quota, that was not taken into account. Neither the state respondents had made any specific statement to that regard or any denial to that regard. The only contention that the writ petitioners were promoted under the promotion quota by on the vacancy created by the other promotees. But those promotees also were in excess of the 50% quota. Now we have worked out.
Yes, you agree to that part. If you agree to that part, it can be disposed of. The promotion will be from the date when the ad hoc,
Lordship,
what you call, regular vacancies are available. If you otherwise you are challenging the whole judgment.
Lordship,
If you confine to only one part of the challenge, we dispose of the appeal.
Lordship.
In that event, the writ petitioners' rights also will be protected. Their seniority also will be protected, my lord. And vis-a-vis the appellants, my lord.
Yes.
But I have not seen the affidavit yet, madam. So I mean, given
They have only identified a vacancy. From that day, they'll be promoted. How can you have any?
This is the,
Hello, can we be taken?
No, it's okay, but
For the matter,
look
I
at-
will
look
have to get some instruction from my clients also. madam.
I'll-
You have a copy. Come to page 5, paragraph 7.
Yeah, copy will be-
Lordship, matter may be fixed for hearing on 29, as because we'll file rejoinder.
I hope you understand what you are asking.
Lordship,
Did you understand what we were telling you?
Lordship,
What did he tell you? What did you understand?
Means 2009 एक दो तो ही
Lordship, I didn't get it.
Did not get it.
Yes,
You see, the
दो तो ही
respondents in the government,
Lordship,
they have admitted that one part of your challenge with regard to the retrospective promotion would be available from the date when the vacancy arises.
Lordship,
In their affidavit, they have given the dates when the vacancy arises.
Lordship,
So if you limit your challenge to that, we allow it. The
Lordship,
petition can be disposed of.
Lordship.
You have objection to allowing of the writ petition.
It may be disposed, Lordship.
Nobody take a call. You are making the challenge to the entire judgment. We find that the entire judgment is otherwise not assailable. It is only one part where the retrospective effect was given from the date of ad hoc promotion. Ad hoc promotion was without any DPC. So that cannot be accepted. So if you admit to that part of the challenge, then there's nothing the appeal. You are also, result will not be required.
Page 6.
At least, my lord, I have to, my lord.
Lordship, I leave it to this honorable court. It may be, it can be done.
From my client and seek some instruction at least, my lord. On Monday, my lord.
No.
My lord will be sitting here, no, my lord.
Okay. Friday for
That
hearing.
is May. Friday and Friday, some January. Okay.
Also as a representative, as the appeal has already been admitted. By
31/2024. Order dated
22/1/2024. Oh, sorry, 30 January 2024. This is the matter for hearing on Friday, is the date of Friday.
My lord, on 28, madam.
28 next Monday. Tuesday. Tuesday. May 28. 28. Next Tuesday, 28.
No, we are not adjourning like that. At best, we can next week accommodate is 21st. 21st.
28. Today's
20, sorry.
Today's 20.
Yes.
24.
No, on 28th, my lord.
Next Tuesday.
Okay, 28.
Lordship, there is no stay. So matter may be stayed till then.
No, no, not required.
Not.
Deeply obliged.
Just record the visits, record the visits also.
No, my lord. My lord.
Also heard Mr. D. Picha, learned counsel appearing for the appellant. Also heard Mr.
Enratan.
Babu for the senior government advocate for the state respondents. Additional legi, sorry. N. Ratan, additional legi for the state respondents. Issue notice, returnable. How much, Mr. Ratan? 4 weeks? 4 weeks. Who is assisting you?
R. Basar.
Ms. R. Masla accepts notice on behalf of all the respondents.
Yes, my lord.
Behalf of all the respondents, the petitioner to appellant to furnish requisite extra copies. No formal notice we issued. Appellant to furnish requisite extra copies of the appellant. Full stop. The admit notice name. Admit. Admit. Then you write admit. List the matter for hearing after on the returnable day.
My lord, I have a prayer for interim, my lord.
Obliged, my lord.
The respondents are at liberty to file their to bring their respective stands on record by filing affidavits, if so advised.
Obliged, my lord.
Not a case.
May I satisfy?
Huh?
May I satisfy? I would like to satisfy.
Your only case is that those office memorandums
Yes, ma'am.
have prevented you from getting a promotion. You don't have a land till now. That land that is there, the government had permitted you to build a building that taking a fee, but that allotment has not come.
Now,
So
what I
how
say,
can
my
the
lord,
DC?
this order, my lord, this impugn orders, my lord, it alters my service condition. My lord.
It does
takes
not.
away my.
It does not. It is not supplementing your condition. It is adding to that. It is supplementing.
Yes, my lord.
And this is a
The new criteria has been added.
It's not a new criteria. It has been there for some time. And this criteria, we given the state of affairs at the field, we at least feel that this should be continued.
This should be continued. Otherwise, everybody will build, even in top of this building, you'll find somebody encroaching.
Encroaching. So let us see how, let Mr. Ratan come up. Sir. Interlocutory application, heard the same parties having considered the prayer as made in the present interlocutory application, and also having considered the reasoning as available in the judgment and order under appeal of the learned single judge, we are of the considered view that no interim order at this stage is called for in the present matter, and the writ appeal is required to be disposed of. The present interlocutory application stands. So there will be no order is called for in the present interlocutory application. Interlocutory application stands closed.
Obviously, obviously.
Just a moment.
Yes. Impugn order is my lord at page 25.
Just.
You see, if you have understood things correctly, in the
Yes.
correct perspective,
Yes.
the you were given the tender.
Yes.
Contract.
Correct?
I was the L1.
contract. And that was, there's an interim order operating.
Yes. Interim order was passed.
If we pass any other interim order, then there will be nothing to decide.
Yes.
And maintainability has been taken up by the as an issue by the learned single judge.
Lordship, what I mean to say is, Lordship, because the writ petition itself was not maintainable, before passing that interim order, that issue should have been decided, at least heard. He has not given a reason why that maintainability could not be decided at that point of time. That reasoning is also not there.
Not filed an IA there for vacating this, like
No.
in the earlier proceeding. You have not.
No. In the first instance itself, in the first day itself. May I suggest, my lord, may I pray, my lord, that the matter can be remanded to the learned single judge to decide on the maintainability, Lordship.
No, that is something we may not do unless you withdraw it. The reason being,
Yes,
you see, we are exercising intra-court appeal.
yes,
So question of remand will not be there.
yes,
What we can decide, we'll decide it.
yes,
But the fact is that remand, you see, we are not exercising appeal within the meaning of CPC under Order
yes,
41.
yes.
In the CPC, there is a provision where in appeal, the matters can be remanded back to the original court
Yes,
or to the first appellate court, it can be remanded back.
yes,
That power in the intra-court appeal under the High Court rules we don't have. So
yes.
therefore, a challenge has to be entertained by the division. That is at least
In
in the
that,
bench, it is my view.
in that case, Lordship,
Because there cannot be a writ issued on a court.
yes,
I can't issue a writ on this High Court saying that the learned single judge will decide the matter.
in a similar case, Lordship, when the question of maintainability was raised, when the High Court did not entertain that, the Supreme Court had remanded the question back
Supreme
on,
Court, you see, is doing
Yes.
something which is under 142.
yes.
So don't compare that powers with our limited powers.
Lordship. I will not press for the interim, then let the matter be decided on its own merit, Lordship.
You see, we're just thinking aloud. We are not forming an opinion, we're just thinking aloud, both of us. If you admit this appeal and keep it pending,
Yes,
then the learned single judge will also not be able to take up the issue of maintainability. You lose.
if there is no interim order, there is no bar, Lordship.
Ultimately, what we can say is that we
Yes.
allow it to withdraw this and move the learned single judge with an application for early hearing on the issue of maintainability. In tender matters, if we takes up the matter, then the division, the single judge won't, in all probability, will not take it up. So you stand to lose both ways. The committee to withdraw and move an application before the learned single judge for issue of maintainability or early hearing of the writ petition.
Lordship, I'll do that.
But Mr. N. Danger, learned counsel for the appellant, and Mr. B. Pichal, learned counsel for the respondent number 1.
No, my lord, 2 to 4.
Or
2, 3, 4.
Who is for 1?
One, the private respondent.
One, the writ petitioner.
He is not available.
I tried giving him a copy, he refused to receive. I tried giving him a copy, he did refuse to receive.
He could not
Yes.
have done it. Then we'll record it. 2 to 5. Next, the learned counsel for the appellant submits that she
Through advocate's
wanted
clerk.
she wanted to serve a copy of this memo appeal to the learned counsel for the respondent number 1, who is the writ petitioner in
WPC 169.
WPC
169.
169 of 2024.
Yes.
However, the learned counsel for the respondent number 1, within bracket writ petitioner, refused to accept a copy of the appeal, memo appeal. Full stop. Next paragraph. In the said context, the court is of the considered opinion that once a learned counsel appears in the writ petition, this appeal being an intra-court appeal, the no, the CBC. I could do this. I could do this. His the appointment of the council would also cover intra-court appeal under the provision of Order 3, Rule 4, explanation within bracket C, which provides the continuation of appointment of a pleader in respect of an appeal from any decree or order in a suit. Full stop.
Four 32 page,
Huh?
432, if you're lost, 32.
432. Thank you.
Down below. Left side, down below, left side.
Read with Guwahati High Court Case Management Rules, 2007. On the clause, sorry, under rule, capital Roman 5, within bracket 1. So therefore, the court deprecates the refusal of the land council for respondent number one within the petitioner to acknowledge receipt or copy of the memo appeal. Next paragraph. After some deliberations, the learned counsel for the appellant has grave leave of this court to allow to withdraw this intra-court appeal with liberty to move the learned single judge with an appropriate application for an early hearing and to take up the issue of maintainability of the writ petition as raised by the learned counsel for the appellants, which is also recorded. It was raised by you.
Yes, sir.
Oh, okay. The issue of maintainability, which was raised
By them also.
B. Pichal and the counsel for. Both of them?
Yes.
By Mr. B. Pichal, counsel for the respondent numbers 2 to 5, as well as the learned counsel for the appellant, which is recorded in the impugn order dated 12/4/2024, passed in WBC 169 of 2024. Full stop. Next paragraph. The prayer with liberty is paid for is granted. Next paragraph. As the court has not entered into the merit of the matter, the petitioner is also at liberty to move this, to file an appeal if so advised. If she is still agreed.
Always.
Six, 7, 8, 9. Interim victim program. Victim sharing. Yeah. Yeah, 22.
Lordship, here, Lordship, service is still awaited upon respondent number 2, Lordship, which is victim.
But the OC will have to serve him after the division bench order of this court.
Lordship,
It has to be served through the officer in charge of the jurisdictional police station.
Lord, it has not returned back, Lordship, as per the record, Lordship.
Stay was taken on the
So
last
we'll-
occasion. We have taken the
We'll
stay.
we'll take it after 10 days. In the meantime, you get it.
Lordship,
Okay. After 10 days, in the meantime, they'll get the service report.
Yes.
We'll give a fixed date.
Right.
Give a date after 10 days. Both sides are represented. Ms.
El Hage.
Hage, learned, additional public prosecutor, prays for some more time to obtain the service report regarding service of notice on respondent number 2 from the officer in charge, Longding Police Station. Next, the learned APP shall send a downloaded copy of this order so as to enable the officer in charge, Longding Police Station, to send the service report. So next, list on 3/6/2024.
And there is a IA, my lord, that is still pending. IA.
No, you see, this is a case where we can't consider that unless the notice is served on the respondent number 2.
Obliged.
You know the Supreme Court directions now.
Obliged.
Obliged, Lordship.
3rd of June.
Lordship, yeah, I have a prayer. This matter can be taken up tomorrow, Lordship, for
Yes, a contempt jurisdiction, my lord, I need not to submit much. The para 12 and 13 at page 35. Or the contempt petition speaks for itself.
वहाँ में कुछ डॉक्यूमेंट नहीं है हमारे पास हम दो एक
Fine.
tomorrow. All right.
My pleasure. Lordship, this IA has been prepared by the for the road organization, who is presently is going to undertake the construction activities, by virtue of the the order passed by this honorable court, wherein the status quo order was passed. So the respondent authorities and the applicant here in is not in a position to the executive work. There are so many other things which has to Main clear card. He didn't find the. Respond number 8 को कौन करता था? लोग राइट है हमने लाइन respond 8 सर्विस कंप्लीट नहीं नहीं कंप्लीट भी सर्विस के बेटे सर तो ये कि नहीं अभी भी नहीं ठीक है
Who is for the petitioner?
Your Honor, I am.
You are for the petitioner.
Yes, Your Honor. Your Honor, we like to file objection in the IA.
Pardon me?
I like to file, we like to file objection in the IA. Matter can be adjourned for today, Your Honor.
In the writ petition, where is the document of re-alienation? Where is that? The realignment of the road, the central line, where is that document?
DPR
In the writ petition?
it is in page number my lord 51 I think
51.
my lord this is the only map my lord. And my lord, to that clear that portion, my lord, we have also enclosed the my lord, the alignment portion in our affidavit, my lord. Affidavit in opposition filed by the BRO, my lord.
No, where is the document? This is a map. We can't understand a map.
My lord, admittedly in our affidavit also, my lord, that particular my lord, the alignment approval is not enclosed. Particular my lord, the order or the my lord, the correspondence wherein my lord, the approval is made. That on documents is also not available in our petition. Only the alignment part, first, this is the first stage where the alignment has to be approved. Thereafter, the other the construction activities will
But
follow.
how do you say you are asking for a prayer to modify the order of status quo? So what is the document based on which we can apply a mine?
It is I'm sorry, that part that documents is not enclosed in the IA. But however, in affidavit and
Becomes better particulars because if you can't apply a mine, because you see from a map you won't understand which side you are taking up. The road alignment is shifting where, the baseline is shifting. It has to be some memorandum so that we can understand.
Time and again, we are making correspondence with the authorities concerned for the at least if there is any approval on written, that is also not made available.
Then we can.
They are only saying that the MAP is the only the approved alignment.
No,
Wherein
this is a topography map. This is a topography map. It's just like the map of India in the geography book. You have the contours, but you don't know what is what. We bring better particulars. We take it up on Friday. You bring us better particulars. You see, we are aware of the fact that this is a developmental activity, and time and again, we have been asked by the Supreme Court of India to be cautious while granting a stay to the developmental activities. But we must have some document to show that.
Yes, madam. Importance of the work is enclosed in the the IA.
So
wherein
take it up on Friday. You bring the particulars. The also is represented.
You want to say a few words?
Through him, please brief him.
Tell him.
Alignment को ऊपर ही approve
Where is
order नहीं वो order दे दिया इसको alignment को ऊपर ही
order?
Sit down. Take his briefing. Sit down and take his briefing. We take it up after 10 minutes, you can go outside, have a discussion and then come back.
My lord,
Just time.
the officer is narrating the same thing, my lord, which I have already queried with him.
Just take his briefing. In the meantime, you can spend the time in some other matter. We'll take
My
it
lord.
after some time.
Deeply obliged.
My lord, IA has been filed by a respondent NSPC seeking leave to file affidavit, which is already on record. Affidavit may be accepted because by way of affidavit, additional facts have been brought on record. What happened in this case was, my lord, the appellant had filed a writ petition stating that their land is falling under submergence, but compensation for the land has not been paid to them. The case of the NSPC was that land has not been acquired. It is also not falling under the submergence. Land is not at all needed by the NSPC. So therefore, question of paying of compensation doesn't arise. There is a very elaborate judgment of Justice Fukan.
Just a moment. Here you're in this IA, the only prayer is to allow.
Seeking leave. Seeking leave to.
You see, we never stopped you from filing any document on record.
Milord, not him. His NSPC, Milord, has filed an additional affidavit, bringing on record certain documents showing that demarcation of the land has already been done.
Where is
This
that?
is the relevant fact.
Where is that?
Affidavit is also on record. IA is 86. The affidavit is by respondent 2 and 3. My lord will find.
Affidavit of 2 and 3.
Yes, that's NSPC.
No, but what is?
Because there are observations of my lord Justice Fukan that there may be a demarcation, applying scientific methods if necessary. But demarcation has already been done. We wanted this court to know.
About the leave, let the leave may be granted, my lord, we will file an objection to the affidavit, additional affidavit. But district administration said. Yes.
Objection to the facts stated possibly. What he's saying, objection to the facts stated. He's rebutting the facts.
All the fair, we will file an objection to that, my lord, because district administration. Yes, my lord, district administration is said, Deputy Commissioner, no demarcation has been done. They have been repeatedly requested. Let the record may be called from the district administration, my lord, everything will be clear.
It is the forest department
Yes,
which
my
has done
lord.
it.
This is the
Forest has
report of
done it.
DFO.
I'll say that.
My lord, this is the report
Just-
of DFO,
Mr.
they have
Tiwari.
been annexed.
Mr. Tiwari,
Yes, my lord.
normally in Bombay and Calcutta, we have a very specified local train timing.
Yes.
If you miss by 1 minute, you lose everything. Here we don't incidentally have it.
My lord.
So we'll give you time, don't worry.
All right. Let him say whatever he wants.
My lord, let the record from the district administration may be
That
called
will
for,
come
my
to
lord.
late petition. Now we are in IA.
Yes, my lord, in the
Now we are
appellate
in
stage, they are.
Now we are in IA.
We will file an
about this-
objection, my lord, let the matter come up on 30.
30.
30, in the meantime. we'll
Make it
file-
28.
Today is
Make it
20,
28.
Tuesday, next week.
30, I'll be here. I'll be here on 30th.
Uh,
Mr. Dikanto Das is there. I have a case with him. So he will also be coming on 30th.
Mr. Das, you are now a matter of exhibit.
So both of us, so
No, I'm just, since I can smile before both of you, I'm just doing it. No offense. Mr. P.K. Tiwari, Senior Counsel, assisted by Mr. K. Saxena, Counsel for the applicant. Mr. S.K. Deori, learned counsel for the respondent writ petitioner.
Appellant.
Sorry, respondent appellant. Prays for time to file objection in the matter. List on 28.
30.
My lord, could it be 30? 28th, there will be difficulty. 30, 30th
No, 30 is the last.
is the last
Friday,
date.
because
Yes,
we'll not
Thursday.
able to-
Then-
No. It's Thursday, but we'll have to pass orders.
Oh, yes, I'll just see, my lord, if there should not be a clash. 28th, yes, 28th, all right.
28, 528.
Let it be 27.
Objection, if any, be filed.
27, no, nothing is mentioned here.
Is
but
one day prior to the next date of listing.
Let it be 28th.
You're also there?
Sir,
Just
Lord,
trying to
let it be
Mr. K.
27.
Kamduk,
No, no,
standing
there's
counsel for
no
the
problem.
land management
28th.
department and government advocate for the state is present, just write the presence. Just one so.
So 28, 28, 28th of May.
I'm appearing for some of the respondents, my lord. And my lord, there's a preliminary objection we have taken last time also. I have appeared for VC that they cannot proceed with this because this is a collateral proceedings. The section 37 as well as the under the Land Acquisition Act, those are dismissed. Those were dismissed, and then again they invoked the jurisdiction under 226. That was also dismissed by the single judge. So my friend has, yes. That appeal was withdrawn, but not withdrawn, the land acquisition appeal was dismissed on limitation, as well as on the ground of wrong section. They did not file the reference. They straightway came and filed an appeal before the High Court. So multiple application, this is the fourth round. Yes.
Okay, in view of preliminary objection, you start your.
Yes, my lord. Yes, my lord. I'm grateful, my lord, because I have the burden to satisfy your lordship. I've taken this preliminary objection. Lordship may have my written note.
Yes, we're taking up the matter. Preliminary objection.
Yes, my lord. Yes.
You are ready?
Yes, yes, my lord. Or my lord, the entire matter can be disposed of, my lord.
No, once an objection is taken, preliminary objection, we take up that first.
My lord.
Lordship may have my written arguments, which was filed. There's a separate index. The Lordship has the written. There's a small written argument. You have a copy? This is the one. Yes. 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 Not this one, the other one within index. Within index, yes. So I have given the narration of the judgments right from the beginning. Lordship will straightway come to. I mean, some of the respondents have filed that. Respondents, the two. Lordship may straightway come to page 4, paragraph number 8. I'll just show the relevant portion. Now, this is the first round of litigation. I've given the heading. So here, my lord, in 2007, this land, there's 4 different locations in the Dibang Valley. And these are under the Assam Rifles since 1955. In 2005, this land was transferred to ITBP. In 2007, but no compensation was ever paid. Now, 2017, first time, this landowners approached the High Court. And there is a direction by the High Court to the DC that find out the status of this land, whether this is a community land or what, and appropriate necessary action. If no compensation is paid, that should be paid. So pursuant to that, the DC inquired gave notice to everybody. Joint survey was conducted. ITBP, the petitioners here are party, appellant here are parties there. They participated in the survey. And finally, notification under section 11 was issued in 10th of May 2018 and subsequently followed by the award in 6th of September 2018. Now, after the award has come into existence, no payment was released. So therefore, Lordship may straightaway come to the second round, that is page 7. Lordship has page 7. I'm just narrating, I'll go to the order specifically. I did not read these paragraphs. I'll go to the orders. So page 7 is the second round of litigation. Since no payment was released, now the landowners again in 2009 approached this honorable court, 2019 approached this honorable court, and 2 writ petitions were filed. In this writ petition, 7th of November 2019, there's a detailed order by the learned single judge directing them to release the payment since they have not challenged the award till that time. Now, against this 7th of December 2019 order, they
Just
yes.
a moment.
Yes.
Pursuant to this first writ petition,
Right.
which you are referring to at the order dated 14/3/2017.
Yes.
Is there any fact finding by the Deputy Commissioner?
Yes.
Where is
There's
that?
that fact finding, Lord. There was a proper award, my lord. There's a joint.
No, the requirement was that whether it's a government land or not. So where is the finding of the government on that?
You know, that your lordship can straightaway come to the award. It is recorded, and that is not the dispute. You know, they are also not disputing this. This is not a community land. They are saying we wanted less land. After the award, they raise these disputes in some of the letters, saying that whatever the district collector has awarded, the department wants lesser amount of land. That is the.
Yes, sir. Who is Mr. Kamduk?
Sorry, ma'am.
Mr. Kamduk?
Yes, ma'am.
You are appearing for the government
I'm for
land management.
land management.
Did the Deputy Commissioner make a fact finding as to who was the owner of the land?
Answered by Mr. Pa, my friend Mr. Pa.
Lordship can have the award also.
No, award is something which comes later. First is if you are reading the first order
Yes.
of 2017,
Yes.
then there is a mandate for the Deputy Commissioner to make that undertaking,
Yes.
whether the land belongs to the community or it belongs to the state. So, did you do that exercise?
No, this is an admitted factor. I will go through the judgments.
Okay, you see, when there is a judicial order, there is no admitted fact. When the court issues a direction,
Yes, madam.
you can't say that there is an admitted fact.
Yes, madam.
It can be anything else.
Malad, this is the findings of the Malad Deputy Commissioner in one of the writ petition, Malad. Wherein, Malad, it has been decided that this is a government land.
Which is this page? Where? Is something part of
It is writ petition number.
Okay, okay. So where is the finding? Finding that. Not out of 6, I'm told, I've just told me out of 6 different pockets, 4 pockets were found to be community land and 2 pockets were government land, Milord. So
You see, we don't know.
yes,
That's why, since we are reading it with a clean slate,
yes.
without any previous understanding of the matter,
Mhm.
you told us to read the first 2017 judgment. We read
Yes.
that. The natural query was whether this
I understand.
land is a government land. Now
Yes.
we have a document on record that 19 December 2017,
Yes,
the Deputy Commissioner
yes.
has stated that the area under occupation of ITTB falls within the cadastral map of Anini Township. Hence, the claim of the petitioner's community land is not tenable.
Exactly. Milord. Therefore, this is not the subject matter of this. Annealing is not acquired under this award. That's my submission. And that I will demonstrate from the records. This, what has been presented, Anini and one more place, out of 6 places, these 2 are different.
This is Dibang Valley.
This is Dibang Valley.
Malad, this is the part of the Malad notification, impugned notification issued by the state.
Where is that?
Not it.
Malad,
Impugned award, Milord.
Malad, that particular Malad page is writ petition, writ appeal number, Malad 104, Malad. Annexure 4, 104 of my writ appeal. 104.
104.
Correct. This is in respect of my lord. Read petition number 11 of 2017. Man.
Is the award you were referring to?
No,
It's a notification.
notification. No, not notification. First round of read petition.
104 is Gita Mihu
Correct.
judgment in writ appeal, in writ petition.
Well, this
And
suit can be
my lord,
resolved if you
and,
also look at the award.
Notification, my
The
lord.
award is clear.
That notification
Just-
is also
just-
included.
Where is the award?
Award is page 175.
175.
Yes. It is annexure 10 colleague.
Just now.
Before that, my lord, notification.
These are different notification for different areas, my lord. We are concerned about 4 areas, which is the award restricts, that is the area of 21
Just-
acres,
just- just-
96. So, Lordship kindly have this the award.
Just.
Yes. The name is different, my lord. The confusion arose because both them starts from the same letter A. 176 is the.
Where is? No, before the award, there must be some notification of
Yes,
acquisition.
that is also there, my lord. Notification is at page 120, 281.
281.
Lordship will see there are 4 names only.
Just now.
Yes. वो नाम से spelling क्या है? Alini. The name is Alini, A-L-I. And that is a different. Anini, A-N-I. Different. And that came under the urban area, town area. And these are all community land. Our award restricts to this 4. In their grounds, they have taken both the grounds. Okay. ये चीज कौन सा है? Okay. हाँ. Page 179. 279. And page 279, my lord.
Yeah, just now.
Yes.
This
Correct.
Alini and Anini are same thing or different areas?
It is, my lord, as per our affidavit, my record, my lord, it is same.
No. If you see in the state, you will know better. A-L-I-N-E-Y, Alini and Anini, A-N-I-N-I, whether they are same or different. Different.
Same man.
Huh?
It is same place, man.
Separate areas.
It is in Anini, man.
Well, their letter 199 clarifies this position.
1?
199. Their internal letter. Because for the 4, including Alini, there is a rate 280 per square meter. For Anini, there is no rate. 199 is a letter from their battalion headquarters to the Deputy Inspector General. Lordship has that 199?
199,
Yes, I am referring to the next page, 200, para 5. May I read that para? In the proposal of all above forward posts, rates of the land has been taken as 280 per square meter. In this regard, the Deputy Commissioner Anini was requested to reduce the rates, but the Deputy Commissioner Anini, by letter dated, has intimated that the above rates are taken for the horticultural land approachable by motorable road, which is prescribed by the government approved rate. The Deputy Commissioner Anini has not provided estimates for the land at Anini and Italin for so far. So these are two different areas. 4 areas, it is 280. There is no dispute, which is part of the award. These two, Anini and Italin, are separate. The award is not yet made by the Deputy Commissioner, still pending.
So spelling is same, Anini, A-N-I-N-I. A-L-I-N-E-Y is not the spelling.
ANI is the headquarter where the DC is the headquarter, and ALINEY is the village where for which the award has been passed. The code is inky where there's a proper by irrespective of this issue will satisfy your lordship on this, but these are issues that they should have raised in the act, in the proceedings before the act. Land Acquisition Act. They abandoned that. They failed and then they did not pursue that. And in a collateral proceeding, they're raising all these disputed facts. Yes, sorry. And 276, 270? 9.
This document you have produced, this document which you have now produced, in the third last paragraph, there's a reference to 26th August 2003. Before that, there's May 10, 2005, and again 24/5/2012. Are these documents available? Because if we read this, my brother has rightly pointed out, that means the Anini Township came after this land was allotted to the ITV. Are these 3 documents available on record anywhere?
Can I have a copy of that? Do you have a copy of this?
It's your documents. I've taken out.
I don't know, it's part of the record. This is something, my lord, has been handed over. This is not part of the record. This is not part of the record, so I'm not able to respond to your lordship.
Just trying to understand.
Yes, yes. And to your lordship's query, my lord, whether there was an inquiry or not.
Just give us 2
Yes.
minutes. You see, there's a reason for asking. Now we have opened up the Google map. The difference between Anini and Alini is 3 hours. Correct. So we don't think that the government would have allotted land to the ITBP, which takes which requires a
In the-
diameter of
City, the town.
3 hours to travel. There is something wrong in your documents.
I'm sorry, Malad, the documents, the date, Malad, the correspondence, Malad, mentioned in this particular Malad order dated 1917, 2017.
135 kilometers it is showing. So I don't think that the ITB would be given a land which requires a travel of 135 kilometers. 9,000 square feet, 10,000.
And to your lordship's query, my lord, 179, DC's letter, he says that 279, I'll just read out that line. The concerned GBs of the villagers have verified that the land belongs to the claimant villagers. So it's
279.
279, yes. Para 18 of page 279. Which is, these are the documents they have filed, my lord, along with the writ appeal.
They have filed this document.
Yes. Para 18, 279.
Just a moment.
It says,
Just a moment. Which July. No, this document, it does not have reference in 272.
279.
No, 272 is the affidavit. There must be some reference to that document.
This is annexure 20, which is part of the writ appeal record.
No, you are saying that it's a part of their affidavit.
Yes.
Their affidavit is at page 272.
No, my lord,
Does
I'm
not
saying
contain
it's part of the annexures which they have filed before this court.
Oh, acha.
That's my submission. So this is their document they
Annexure 20.
produced.
No, let us see what is the statement.
Yes, it satisfies your lordship initial query that whether there is any inquiry or not. Para 18.
Just now.
Yes.
Unless you look at the
279.
reading, I won't understand anything.
Two seven nine para 18. This is signed by the deputy commissioner at the bottom of the page.
Just a moment.
Yes.
Yes, this paravise comment is not covered by your statement in the writ appeal. This document has come from where? To page 278.
Malad, this is the internal communications made.
No, we are not interested in that. In your writ appeal, page 20 collectively is para 1.23 at page 29.
Malad.
It does not have a reference to it. How it has come on record?
What can I make out from the index, my lord? Lordship, they have bunched a couple of things together at annexure 20. If your lordship sees serial number 22, this is all bunched together, and along with that bunch, this has also come on record.
It couldn't have been brought like that.
They have not mentioned.
They have not mentioned in the index or anywhere else. There is no reference. But when we
Don't do it. You can't bring documents like that in an appeal without there being any reference to this. That itself is a good ground for dismissal of the appeal. You must take responsibility. Somebody, when swearing an affidavit, must take responsibility to each and every document which is brought on record.
My lord, it is in original page number, my lord, 29 of my appeal, my lord. Roman 123, my lord. Page number 29 of my appeal.
I'm there at page 29. Read it. Where is the reference to this document at 278?
So, my lord. The appellant begs to state that the private respondent filed IA number so and so, but no reply filed by the Union of India oblique ITBP. The appellant further stated that the Union of India oblique ITBP filed SLP number so and so before the Honorable Supreme Court of India, challenging therein the order dated 15 June 2022. Passed in the writ petition number so and so, and order dated so and so, passed in the contempt case number so and so. The Honorable Supreme Court of India, by order dated 0508-2022, issued notice and state the contempt proceedings on the instruction on the conditions that the petitioners deposit the amount as per the order of the High Court within a period of 6 weeks. Therefore, the commandant 9 BN deposited so and so amount on the direction of the Honorable Supreme Court of India as above in the account of the Deputy Commissioner and any districts so and so on dated so and so. My lord.
Why we are saying that your documents must be responsibly filed? You come to page 279, read paragraph 27.
The said land, the said land was indeed occupied by the Assam Rifles, and the later had been transferred to the ITBP, but no documents exist with the district administrations regarding the land occupied by Assam Rifle at said BOPs. Regarding the issue of the declarations of the community land of the said BOPs, both the party ITBP and the villagers had been given opportunity to prove the ownership of land. Further, prior to any acquisitions matter, the land was to be allotted to the ITBP with the deposit of the said of land revenue to the occupied land for the occupied land. Since the villagers had filed the writ petitions for the land acquisition process, the government with non-acquisitions of the land cannot transfer the land to the requiring agency.
So that means this parawise comments is authored on 5th July 2022. So till then, the government doesn't take a stand that this the Deputy Commissioner already said that it's a government land. You don't take that stand. Therefore, you are manufacturing stand for the purpose of this court. You are at your convenience, you are taking up stands. If that land was occupied without any documentation, then you have to show us that this is the manner in which the area has been mapped. It has been what you call the finding of fact about the land which is in occupation of the respondents. That was done. You are not showing us those.
That is the exactly case of the ITBP, Malad. In the
You
year,
see, then your appeal fails. We don't decide things on the basis of hypothesis.
exactly.
Actually, if you're not, if you see, you took up the land on a particular date. After that, there's a land acquisition proceedings. And therefore, till date, we are not certain about what is the land. So, way back in 2022, when you give a parawise comments to your lawyer, then also you don't take up responsibility. You don't know what the land is about. And now conveniently, at the convenience of
exactly
the
this is the case.
appellants, you are coming up with one document and another. Now you are showing us this document. Nobody bothers to have it supported by an affidavit. You just produce things and then take the court for granted.
Malad, I'm sorry, Malad, that Malad case is also pending before the Honorable Court
Then we dismiss your appeal. If your facts are not straight, why will you?
Therefore, Malad, the facts of the case is required to be Malad, the heard first Malad. What happened, Malad, in this
There's
case?
nothing to hear. If you don't show us the manner in which the documents are created to show land which is in occupation of ITV, there's nothing to be heard.
Malad, for a moment, Malad, may I take your lordships to my annexures, Malad, page number?
No, you see, please show us any document which makes what you call intelligent reading. We have told you, we have disclosed before you our thought process. It started, emanated from the 2017 judgment. From there, we want to understand what is the process undertaken by the state government and the ITB or the Union of India to have the land ascertained. June 2022 also you don't know what is the land.
That is the exact the contentions of the ITBP that without there being any requisitions, so how much of land
That's
area
totally
and
correct.
is required to be taken from the the villagers or the district administration. That determination was not done,
Mr. Kato, with the technology in hand, even the learned council could have gone to the place with a mobile on, have the map on, and then taken a round, which will give you the exact location of the places we are going. You take a photograph in the Google map, your latitude, longitude, everything gets mapped, and you can find out, even if it is a non-cadastrally mapped area, you can still find out the latitude, longitude, the of the area. Nowadays, if you work with your mobile, it also takes up the measurement. You don't even need a theolite.
Without there being any measurement, without there being any the
Joint measurement took place, joint measurement. It's on record. Joint measurement, ITBP people who are present, DM's people who are present, joint measurement took place.
Where is that?
Yes, my lord. Kindly have page number. There's their own letter, my lord, page number 199. I've shown that letter, but the paragraph 5, 1 and 2, it will clarify everything, my lord. Page 199. Lordship has 199. It's 6th of December 2018. It is their internal letter after the award, but they are admitting the fact there is a joint survey and they participated in that. Yes, my lord. Page 199, Lordship has. Para 2. Assam Rifles has mentioned that the area of the land with an assumption without any layout and land documents. Sorry.
Para 2.
Para 2 is the posts have been opened by the Assam Rifles in 1955 to 1959, which were later handed over to ITPP. Construction on the shown land has been done ever since past, and combined survey was done by the Deputy Commissioner Anini and 7th Battalion ITBP. Accordingly, besides integrated posts are to be constructed in this. Now, para 3 also. It says Assam Rifles has mentioned area of land with an assumption without any layout and land documents. The area after combined survey was found equal to the area as mentioned. These are all done, my lord. All procedure was followed. Presently, there is no requirement of dropping zone. This is the first time, my lord, after the award in September 2019. This is the first time they internally write out of the whatever land that has been acquired, that is 21 acres roughly. These lands is a dropping zone they don't want out of 3 locations. And this fact was communicated to the DM next year, 2019, July. Dropping zone, my lord, the aircraft probably comes or a helicopter comes and drop from the air. So there is a designated place for that. So now after the award, they write to each other saying we don't need this. And this they communicate in next year, July. That letter is also on record. So what will DM do? And all this year, they're in occupation of this. So they are taking contradictory stance, my lord. Here the point was that joint survey was done. So they are saying they're not aware, no measurement, no intimation to about the award. These are all wrong, my lord. The very day award was passed, the DM wrote to them saying this is the award. And before the award, they also prepared their own estimate. The measurement was done by them. They also measure the area, prepare a chart. The amount mentioned in that letter is higher than what DM is granted. I will show that, my lord. Yes. Lordship, might kindly have page 164. Lordship, may I have page 164. This is dated 10th of August 2018, just before the award. Award is 6th of September 2018. Lordship will see at page 164, para 2. This is a letter written by the ITBP to the DC. This mentions one table where the area of the land to be acquired and the extent is mentioned. I will just demonstrate because this table squarely covers with Schedule 1 of the award. Identical land, whatever they asked, DC acquired and given it to them. There was no, only after the award, 1 year after the award, almost 10 months, they raise objection. So this letter, para 2, during the survey in September 2016, area of helipad of MIPI post was also measured for 4,840 square meters, but area of MIPI helipad is not mentioned in draft notification issued by your office.
This is letter dated 10/8/2018.
Yes.
Yes.
It says, therefore, it is requested that kindly include 4,840 square meters with fencing area of MIPI post. So they are asking to include helipad in MIPI. You have not taken into account in the draft. Para 3, in this context, it is also intimated that the area taken by your office in draft notification are not matching with the strip alignment plan approved by the district administration. Actual area as per approved strip alignment plan is as follows. So they give the location, the area, and the strip alignment. So here, 1, 2, 3, 4, kindly have 2, point number 2. It says 4,000, it is MIPI plus helipad. There is one additional. And 4 also, Malini, it says not included helipad area. So they wanted these 2 helipads, these areas from the draft. Now, kindly have the award. Page 175 is the award. That is on 6th of September 2018, just after 2 months. And Schedule 1 is the exact area that has been page 176 is the schedule of the award. Award starts at page 175. Lordship has that page 176. The first location is Alini in page 176. Lordship will see that divided Alini, there's only one.
Just
Yeah,
a
sorry.
moment.
So I'm just trying to compare, Milord, page 176, yes. So, Milord, yes.
It's not page 175, what you are trying to show us?
Yes, Milord. Milord, what I am trying to show, Milord, 176 is the schedule which has been acquired under the award, and page 164, which I have already shown, which was the request from the requiring department. So it is, I can demonstrate, Milord, 4 locations It is divided in page 176, Alini camp, and the area is 9. Compare, that is with page 164, Alini is at serial number 3. Identical area, 93. So whatever they have asked for, that was given. Milord, writ petition they haven't filed, but the orders are on record, all record. That will clearly show, Milord, that they wanted to set aside the award. That was the prayer and the notification.
No, this is an appeal.
From the in the writ petition,
Where is the copy of writ petition annexed here?
that was not brought on record, Milord, but the order is on record. That is 7th of December
You have a
2000.
copy of the writ petition?
You have a copy of the
You have a copy of the writ petition?
I'm sorry, Milord, that is not available.
I will just.
Two writ petitions, my lord, 211 and 190, my lord.
What is the prayer in the writ petition?
I will just show, Milord, but what I could recollect, Milord, it is notification of 10th of May 2018 and award of 6th of September 2018 that is to be set aside.
Who's filed the writ petition?
ITBP and Union of India.
Then your writ petition will not be maintainable against the order of against the award. What is the remedy available?
My lord, before this on the court.
That
Why?
is the impugned judgment.
Under
Milord.
the act, you don't have an appeal provision.
No, my lord, only that is the my lord, as I, my lord, on
They
the last
filed
question
and
I
it was
pointed
dismissed.
out.
They filed the appeal without reference. They straight away filed
No,
the
my
appeal.
lord, reference cannot be made by the ITBP, my lord. Requiring authority, my lord, rights is very limited, man.
Lordship has that.
190 of writ petition and 211 is
Just
the
now.
two writ petitions, my lord, filed by the ITBP.
May I read the impugned order? All the past history has been taken into account.
Just, you know, we are, thought process, just give us some time. So right to fair compensation. Right to fair compensation.
Very nice.
63, madam. Section 63.
Hmm. Sixty-four is the reference, and after that is the 74. That's the appeal.
Reference I cannot, my lord. Therefore, my lord, the only section 63 is the remedy where, my lord, the award can be challenged and the notification as well.
No, the 64 says any person.
74
appeal
is, my lord,
against this decision of the committee. The appeal against whatever is decided under 64, the appeal lies under 74 to the Honorable High Court. Authority, any person interested who has not accepted the award. So they are interested, they are not accepted the award. They should have referred this.
my lord, kindly see
They
definition
filed
of
this.
interested
My
person.
lord, it's not that they do not, they filed an appeal. Determination is 69. Lordship is right. Determination is 69. And decision of 69 goes to High Court under 74. Appeal to High Courts. So they take recourse of this.
In state of Arunachal Pradesh.
Notified, my lord, the reference.
64, with reference to section 64.
64 is district, my lord, the magistrate, district judge, my lord. District judge.
Notified.
District is notified.
It's
Notified,
notified, yes.
Then why we should entertain this
my lord, only interested party is allowed to, my lord, my lord, may kindly see the, my lord, definition of interested person, my lord.
64, my lord.
Interested person is defined under section, my lord, under section, my lord.
It's just. Which provision? X. All persons claiming interest, so and so.
Yes, my lord. Section 3, subsection X, my lord. This is the whole reason, my lord, that we, my lord, could not, my lord, approach before this honorable court under 226 and 2027, my lord. Interested person is, my lord, defined. Person interested is very limited, my lord. We are the requiring authorities, my lord, the requiring body. So we have to, my lord,
So they filed, my lord, under this. Impugn order कहाँ पे है? कौन सा page? कहाँ से शुरू करें? Rituraj Biswas, my lord. Rituraj Biswas. My lord, just to complete the facts, my lord. So after the award was passed, my lord, since the payment was not released, now what they have done, we had to approach the villagers again, approach the High Court, my lord. The order is at page, in my written note, I have collated all the orders together, page 27. That is 7th November 2019 order. I will just read out the operative part, my lord. That is at page number 34 of my written note. This is the single judge in the third round of litigation. So it records page 15. In the instant case, in view of the fact that no efforts have been made to challenge the legality and validity of the award and no steps have been taken to make reference by the collector, it would not be within the ambit of scope of the learned CGT to point out lacuna in the award. It is established principle of law that when a statute recognizes a particular mode to do a particular thing, that must be done in a prescribed manner only and not in any other modes. Now, para 18, my lord, accordingly, this is the final. Accordingly, the writ petitions are allowed, directing the respondent authority to immediately deposit the awarded amount in the office of the Deputy Commissioner Anini within an outer limit of 3 months from today on such deposit. Deputy Commissioner would make necessary steps to release the same to the petitioner in accordance with the law with the proper identification. Now, after this award, my lord, they challenge this judgment in 2 different writ appeals. The orders are at next page 36. So they challenge this in page 36 and the order is at page 38, writ appeals. So this, what they do is, my lord, last para, page 38, it has been submitted that the appellants are proposing to approach. Yes. So, my lord, I just want to point out there were 2 2019, single judge. This is 6/6/2022, but
Yes, after this
yes,
order.
so after the single judge order, my lord, they filed two writ appeals. One writ appeal, that is 196. 196 of
96
2020.
or 195?
No, my lord. 196 was disposed of prior to 195. That is what I'm pointing out.
Okay.
195 was disposed of. Lordship may record the date 7th of October 2021.
This
Disposed of it
195 was filed against what?
against the single judge order of 7th of November 2019.
7th
November, yes. So both the writ appeals challenged
This was disposed of?
on 7th of October 2021. The writ appeals, the
Yes.
196.
Another appeal?
Another appeal 195 has been disposed of on 6th of June 2022. Basically, this too they withdraw, saying he will go under the act. That court is against them. Correct. When they realize.
6th of June.
Yes, 6th of June 2022.
And 196 of 22 was disposed of?
7th of October 2021. 196 is prior to 195. 7th October 2021. So when they realize key court is against them, they withdraw with the permission to approach the proper appropriate forum under the act. So when 7th of October 2021, 196 was disposed of, they filed an appeal under section 74. That appeal also got dismissed in December 2021. That appeal, your lordship, the order, that order is at page 40 of my written note.
This is section 74 appeal.
Yes. So page 42 is the the order starts. Page 43, one important para is the state government opposes their appeal. Appeal filed by the Union of India. Page 43, middle, second para. Learned Advocate General appeared and opposed it. And the finding is at page 44. May I read? It appears that page 44, last para. It appears that from the perusal of the aforesaid provision, that the appeal under the said section can be referred when an award has been passed under section 69 of the said act, and no such award has been made under section 69. Learned counsel for the appellant also contend the same. Besides, the appeal has not been preferred within 60 days as provided in the proviso to the subsection 74. In view of the above, the submission advanced by the learned counsel, I find this appeal not maintainable in the present form. So this was dismissed, 74. Instead of challenging this and taking whatever ground, they abandoned that totally under the act. They filed a fresh writ petition, 2 writ petitions. Yes, and before that, my lord, I just mentioned, my lord, 195 on 6th of June 2021, 22. So in between, this appeal was dismissed. They also took permission from the division bench saying he will go before. They did not inform that their appeal is dismissed. They misled the court. That page, the order at page number 38. 38 is 6th of June 2022 order. When their second writ appeal of 195, they withdraw it, saying he will go. By the time their appeal was dismissed, they did not inform. They totally misled the court. Page 38, last para, it is submitted that the appellants are proposing to approach the competent forum. Lordship has page 38. This is the 195, my lord, which was disposed of on 6/6/2022. By the time in December 2021, the appeal was dismissed under the Act. And they has not.
We'll take a small break and come back.
Lordship will, after the, very well, very well. I'm grateful. Just show the 6/6 order, which they will not be included, but they did not include the appeal has been dismissed. Now the next order is page 51, 8/6/2020. We file a contempt. Saying that they're not concerned. In the contempt, there's certain observations. It's the frustration of the court is also coming out now. Page 57 is the final part. 57. Second paragraph. The order in the contempt. While refraining, I'm sorry.
Yes.
Page 57. While second para of that, while refraining to make any comments on the merits of the writ petition at this stage, it prima facie appears that the writ petition has been filed only to delay the matter. The court also expresses serious reservation on the maintainability of such writ petition, inasmuch as the statutory remedy for filing appeal was also taken recourse to by the respondents, which was dismissed by the order dated so and so. This court, therefore, is prima facie of the view the respondents have willfully and deliberately disobeyed the order of this court in the order dated 7/11/2019, and therefore it is a fit case for personal appearance of all the respondents are required to be made. At this stage, learned so and so makes a prayer that since the second appeal has been dismissed recently on 6/6/2022, some time may be given so that the order in question can be complied with. This court is of the opinion that the prayer made is a reasonable one. Therefore, in view of the fact that the order of dismissal of the second writ appeal is a recent one, the order proposed to be passed by the person passed of personal appearance is deferred and would be considered on the next date of granting a reasonable time for complying with the order. List on 6/6/2022. So what they took time and then challenged this order before the Supreme Court, filing an SLP. This order, as well as order rejecting stay of the award. So Supreme Court issued notice, but told them to deposit the entire award before the DC, which they did. And after that, Supreme Court has dismissed this SLP. So this is a complete chain that is concluded, my lord. Now, the impugned order records everything. Now, where is the impugned order? The impugned order is page 59, my lord, of my written note. Now, this is the impugned order before your lordship in the writ appeal. Page 59, it starts. Kindly, 72 is the relevant part, para 18 onwards. I think by this time they know. Para 18 at page 72. Page 72.
Yes.
Yes. Para 18, Milord, in the instant case, there is no manner of doubt that following the provisions of the Act of 2013, an award was passed on 6/6/2019 by the Deputy Commissioner Dibang Valley. The said award being passed and published in accordance with law, if any party was aggrieved by the same steps as per the law should have been taken, which was not done, and it is the land affected persons who thereafter have to file writ petition in this court in the year 2019 to get the compensation as per the award passed. The writ petitions were decided by hearing both the parties, whereby the awarded amount was directed to be released within the time-bound frame. Para 20, the Union of India had filed a separate writ appeal as indicated above. However, both appeals were dismissed by the Honorable Division Bench, against which no further appeal has been preferred. Further, though the land appeal was preferred being LA so and so, this court by the order dated 10th of December 2021 had dismissed the same as the same was not maintainable. Even the said order of dismissal of 10th of December 2021 has not been questioned in any appeal. After the aforesaid developments, the question that arises is whether a fresh round of litigation which has been instituted by the Union of India, that too by filing 2 number of writ petitions, which with same prayer is maintainable. Next page, my lord, across the page, para 21. Therefore, said conduct of the Union of India in filing 2 number of writ petitions in the year 2022, in the opinion of the court, is barred by the principle of res judicata, inasmuch as there is a conclusive determination of the issues in the earlier round of litigation in the 2 writ petitions submitted by the said Union of India, who had gone up to the level of writ appeal before the Honorable Division Bench, and the order passed in writ appeal has not been put to challenge in the Honorable Supreme Court. However, the second writ petition, being so and so, is clearly barred by the principles of res judicata, as the same has been filed with the same prayer as in writ petition 190 of 2022. Another issue which has arisen for determination is the question of limitation. Though in the writ petition there is no strict applicability of Limitation Act, which is required to be seen as the question of laches in approaching the court, which is a court of equity as indicated above. So therefore, my lord, finally, my lord, page 75, para 26 and 27. So both the writ petitions have been dismissed after discussing all those principles. So here, my lord, there are 3, not only res judicata, my lord, constructive res judicata and the finality of judicial proceedings, my lord. There is a specified process which has been mentioned by the Act. They invoke that. They take permission from this court, a writ court, invoke that, file it, and when it is dismissed, my lord, they again invoke a separate set of proceedings. So in a collateral proceeding, my lord, whether your lordship would examine the merit at all, that is my primary submission, my lord. Even if your lordship, I have demonstrated, my lord, I'm not shying away from the facts also. Even if lordship wants to examine, my lord, I have shown, my lord. Whatever facts, these are all grounds which was decided by the DC as per their own request. Whatever extent of land they wanted, that has been granted. And their figure was higher. The compensation figure was higher than the DC that was awarded, my lord. So in view of these principles, my lord, because these are issues they ought to have raised, and if they have not raised, my lord, they could not have proceeded further. And after the dismissal of the land acquisition appeal, my lord, the remedy was available to them. Even after dismissal of the second writ appeal, my lord, second writ appeal, when they said we want to go back, they could have pointed out that issue that it is not, they cannot file a reference, that it's barred by the under section instead of withdrawing it. They did not press it. So series, I say it's 4th round. In my written note, I have stated it's the 4th round of litigation, my lord, and they are raising repeatedly the same issues. So yes, my lord, even this writ appeal before your lordship is a delayed one. After 78 days they have filed. There's a delay application, condonation application is also there. So here also there is a delay of 74 days. 74 days. Yes, there is an application for condonation of delay.
Yes.
I mean, there is no order of condonation, but it says that appeal is admitted. No reasons is mentioned. I don't know the. It shows, I'm not on the, I don't want to reopen that, but it shows their conduct. Even filing this appeal after 78 days delay, they filed this. But there is no specific order. I'm just want to point out as there is any reasoned order condoning that delay.
My record also was condoned on 31, 1 2020.
I am not raising any dispute on that, I am only referring to their conduct. The writ appeal was dismissed on laches. Even the writ petition was dismissed on laches. Even the writ appeal, there was a delay. That to that extent, I want to point out. My main grievance is, repeatedly they are using the same grounds in different forums, They're invoking 226 writ appeal, they're going back to the act, filing appeal, again coming back. And on facts, just to. Yes, 31/1/2023 is the order. Only it mentions appeal admitted. There is no reason order for condoning the delay or any mention of delay condone. Even on merit, what they are saying, initially they wanted helipad access land before the award. Now, just to complete the things, even on merit, now, if your lordship kindly have 183 page, it's their own letter. It is clarify everything.
31/1/22.
Yes, ma'am.
It is two orders.
There may be separate orders. There may be separate orders for the two rate petitions, but I have only one order. Two orders, I'm sorry. I only have one.
But 256 में हो गया.
इसमें नहीं हुआ.
I'm sorry, Manoj, I don't have the access. I should have checked that. There is some.
No, there is another IA.
Yes.
257.
Yes.
There's no order passed there.
My lord, this is in respect of other appeal, madam.
No, whatever way, it's not there.
Yes, yes, madam. Admittedly, madam. In item number second, item 12, my lord, it is there,
Okay,
madam.
but it's not there. It's an order in 256, not in 257.
256 would have been 41.
My lord, therefore, my lord, if, my lord, considered, my lord, the item number 11, writ appeal, my lord, 41. If, my lord, this writ appeal is allowed, my lord, automatically the same notification, my lord, this is out of same notification, my lord. The mistakes done by the, my lord, department is also, my lord, in respect of, this is same
What's your-
notification,
what's
out
your
of same
reply?
notification.
What is your reply to this, to the submission on maintainability?
My
What
lord.
is your reply?
My lord, my reply is, it is very much maintainable as because, my lord, first, my lord, before, my lord, going into the, my lord, that award, which, learned, the friend has referred, is, my lord, out of, my lord, the notification, impugn notification issued by the respondent, state respondent, my lord. The state respondent has, my lord, issued this impugn notification. And that notification has been, my lord, issued by the respondent authorities by of their own without taking, my lord, the consent and the obtaining the willingness certificate from the, my lord, the requiring body, my lord.
Where is that?
Therefore, my lord, the relevance on the part of the state respondent affidavit is very much required, my lord.
Which page?
Page number, my lord. Page number, my lord, it starts from 231, my lord. It is in respect of, my lord, what happened, when the 211 writ petition was filed.
231 is an affidavit in opposition.
My lord, exactly, my lord. Wherein, my lord, the state respondent has categorically made a statement, my lord, there was no procedural followed, no procedure was followed for acquisition of this, my lord, the issuance of this notification, my lord. my lord, specifically, may I take your lordships to page 233, my lord. Same annexure 19, para 4, my lord. Para 4, my lord, may I read, my lord? That in regards to the statement made in paragraph number so and so, so and so, so and so of the writ petition, the answering respondent humbly begs to state that going by the previous record from 2006 to 2016 and the series of the communications between the deputy commissioners and the ITBP, admittedly, the DC asked the ITBP to deposit the land revenue at the rate of 10 per Rs 10 per square meters, amounting to Rs 1 lakh 71,004. Altogether, this is piece of land, all 5 piece of land. Now, next page, madam. It is in respect of all, all focus, described in the impute notification. Second page, madam. Italian and as one-time land revenue in the year 2008. The ITBP got its sanctions from the Directorate General ITBP in the year 2016. It is pertinent to mention herein that the private respondents herein claiming to have interest in the land in the year 2017 by approaching this honorable court by number so and so writ petitions, which I have shown, it is one of the writ petitions, wherein the Honorable High Court, taking cognizance and directed the DCs to determine the ownership of the land first, the land for which the award was preferred more than the land required and handed over by the Assam Rifles, which vehemently objected by the ITBP on the grounds that for acquiring more than the land required, it is mandatory to obtain the willingness certificate from the requiring authority, in absence of which the land acquisition process was void ab initio. This is the exactly statement made by the state respondent in the connected the writ appeal. This was filed by the Deputy Commissioner these Anini Malad. And Malad, the relevant next page is Malad. Anyway, Malad, on behalf of the state respondent, Malad. Next paragraph, Malad.
The lordship will see that note is on page 271. In violation of that note, the circle officer files. He says my senior officer is not followed. Page 278 is the comments to be filed.
Malad, may I complete the paragraph, Malad?
Circle officer, I don't know. It should be at least an undersecretary when the activity is filed with the lordship on oath. The circle officer filing and totally taking a different stand. 278 and 278 is the comments which they have filed of the DM.
Malad, may I complete? Let me complete.
Just let him complete his part. Let him complete his part. Let him complete his part.
Malad, next paragraph, para 5, Malad. I'll skip the humble defendant begs to state that there were some errors, errors in the land acquisition process. The DC, without obtaining the willingness certificate of the requisitions from the requiring body, has passed the award on his own. Moreover, there is no difference in the area of the land handed over by the to the ITBP by the Assam Rifles, and the lands to be acquired as per the award, which signifies that the acquisition process was not carried out properly, Malad. And the next, Malad, I'll skip my other person. The answer is the defendants humbly begs to submit that since there are errors in the land acquisition process and the respondent number 3 fails to comply with the directions issued in the order dated 18 January 2017, Malad, that bunch of writ petitions, Malad. And on 14/3/2017, passed by this honorable court in Malad.
Who is respondent number 3?
Deputy Commissioner, Malad. Deputy Commissioner, Malad. And my lord, paragraph 6 is also my lord require, my lord, the specifically mentioned, my lord. And my lord, relevant to this, my lord, this, my lord, the particular willingness is required. My lord, may kindly peruse the, my lord,
Now, please tell us, is it open to the circle officer to say this? Who is the land acquiring authority?
my lord, circle officer is
That's
instructed.
okay. I know that. Even a small fry, in English we say it small fry. In election petitions, you will find the Supreme Court using the word little men.
My lord, admittedly, my lord, in most of the, my lord,
Proceedings of
cases,
Representation of People's Act, you will find the Supreme Court using the word little men. Now, I'm asking you
my lord,
that the Deputy Commissioner is not doing well, not acting correctly, is open for the circle officer to say that. Who is the land acquiring authority in the state of Arunachal Pradesh? In Assam, it is the Deputy Commissioner or District Commissioner now. In this state, who is the acquiring authority?
DC, my lord.
District Commissioner. So this person is incompetent to make a
My
statement
lord,
about
he
it
has
to
been
the officer.
instructed to file, my lord, my lord,
Where is he saying that he has
my lord,
been
that could have
instructed?
been, my lord, my lord, may I read, my lord, first paragraph, my lord. Same annexure, affidavit, my lord, 19, oh, sorry, 232, my lord.
The
Second
answering
paragraph,
respondent directed me to take steps in the matter.
my lord. He is serving under him, my lord, Deputy Commissioner, my lord, subordinate, being subordinate officer, my lord. He has been, my lord, directed to file, my lord, take steps, my lord.
Yes. Additional, sorry, you're the additional AG now? Senior government advocate. We'll ask him to produce his letter of authority. Deputy Commissioner gives him authority to write against him. And he says that the Deputy Commissioner has done illegality. So the Deputy Commissioner is under the scanner now. I hope he's still holding any government post. This Deputy Commissioner.
Malad fails to make submission in every affidavit, Malad. This way, Malad, the state respondent is filing Malad
Okay.
affidavit.
It was asking him.
My lord has in the paragraphs comment forwarded to the Director of Land Management. It was forwarded on.
No, let him complete. Let Mr. Kato complete his part.
Malad, in such case, the willingness certificate from the requiring authority is required as per the Malad, the rule 3 of Malad, the right to fair compensation rules 2000.
The Union of India had filed this. Where is a copy of this writ petition? 211.
211, Malad. Writ petition filed by the Union of India, Malad. Challenging the Malad, the impugn notification as well as the Malad impugn award, Malad. Notification was issued by the Malad, the Secretary Land Management, and the impugn order Malad award was passed by the District Collector, Malad. Lordship will find the impugn notification.
Yes.
Commissioner of Secretary Land Management.
Just now.
My lord.
Mr. Khatto, one query. This land, before this proceedings, they came up before this court, was with Assam Rifles from 1959. Then you inherited, I'm using that word to understand.
True.
Say there was 10 katha, you inherited 10 katha. You had no objection that we don't want 10 katha. These objections came up subsequently when the proceedings were going on, and now maybe in the affidavit of the government, they have taken that plea. But the question here is, in 2017, in a proceeding before this court had required the government to come to a conclusion whether it is community land
Correct, ma'am.
or our everything now gets a little bit murky. Where is that determination?
My lord, in our, my lord, precisely in our affidavit, my lord, in our
No, we want the document.
my lord, there is no, my lord, any determination, my lord. No, nothing was done, my lord.
Who would be the person to answer that question, Mr.
Deputy Commissioner, my
Pinchal?
lord, as well as the Land Management Department, my lord. My lord, therefore, the documents which I produced just now, my lord,
See, in
is in relating
2017,
to.
there was a requirement that the government will, DC will look into whether this is community land or private land. Now, you have an affidavit here. Subsequent action, be that as it may. But what happened to that determination? Was that determination made, or without making that determination, considering it to be community land, you pass the award? No, you will have a document. You have to have a document.
No, so the document is here in the writ appeal, sir.
That determination.
Yeah, there is some reflection of determination.
We don't want any reflection. We want the original. We don't want a mirror picture.
Nothing
We
was
want
done.
the original. Get that original record from the Deputy Commissioner.
Grounds in the writ appeal, ground page
Mr.
46.
Counsel will not go into that. We are a court. We'll also have to look into that.
Very
Things
well,
have been
very
done in a manner.
Very well. I'm
So
with your lordship, yes.
we'll satisfy ourselves.
Very well.
Otherwise, I have already indicated that plea that they are trying to take now.
Correct.
When they inherited that land,
Correct.
they were very happy.
Yes, I absolutely.
So that also we'll have to consider.
Yes.
But at the same time, this court had directed.
Yes.
We want to know what happened.
Madam.
When?
Yes.
Friday?
You see, Mr. Viswas.
Yes.
Just to elaborate what my brother is saying.
Yes.
You see, there is two clear aspects in the matter.
Yes.
Number one, we don't follow the 2017 judgment.
Yes.
The respondents do not follow the 2017 judgment of this court. And then this Deputy Commissioner, through Circle Officer, admits that what he did was incorrect.
Which is contrary to his own.
No,
record.
whatever is that, but there is now an affidavit and
Correct.
the Circle Officer admits that he has done wrong.
Correct. So therefore, my lord, if we,
That's wrong.
sorry.
That is one part. So if an illegality is committed,
Yes.
then in collateral proceedings also,
Yes, God. Yes, yes.
the court
Then
has.
your lordship
this
is
a court of
absolutely,
equity.
yes, absolutely.
Nobody
That-
can stop us from
Yes, yes, absolutely.
attending to the matter, despite 2 rounds of earlier litigations
Absolutely.
being
Therefore,
over.
I submitted, my lord, on
Just-
facts
just-
also,
just-
I will
just-
satisfy your lordship.
Just a moment.
Huh.
Second thing is that we can also take a plea,
Yes.
what you call a view, that once in the previous litigation, these were not taken up. Now, whether they are stopped from raising it.
Yes.
Now, the question is that now they are not raising this.
Yes.
It's the Deputy Commissioner through the Circle Officer comes and admits it.
Correct. Correct.
That whatever done was illegal. Now you
Correct.
see, rightly or wrongly, whatever orders are passed in the writ petition, there are several writ petitions. We won't remember the writ petition numbers. One of the writ petitions says that the Deputy Commissioner will acquire the land.
Correct.
Now, an acquisition of the land cannot be by the order of the High Court. It can only be when there is a requisition by the requiring authority department. There cannot be a land acquisition without a acquisition of the land.
Correct.
So if you see, once you give a land to X
Yes.
free of cost, he's
Yes.
enjoying it.
Yes.
There's no problem with that.
Yes.
When it comes to payment, then they say that well, you take the requirement from us.
Correct.
They give a requirement that this much plus helipad. That is the requirement given.
Correct.
So the land acquisition process. The question to you is, can the land acquisition process proceed first
Yes.
and then what do you call, without a requisition from the
Yes,
acquiring
yes,
authority,
I will answer that.
an explanation can come forward
Yes.
that I want 10 square feet land
Yes.
plus 15 square feet land.
Yes, Your Honor.
Is that the manner in which land acquisition proceeds?
Yes. Well, as far as their argument that the willingness or consent from the requiring Lord, Lordship will recall this land is with their possession since 1955. And their own record I've shown 164, the chart that's shown. That shows this is the extent of land we want. DM passed an award on the basis of their own assessment. So consent already they are in possession. They are giving this is the extent. Willingness is already inbuilt in it
It
because
can't be in a proceedings where the government is a party.
yes.
There cannot be something which is called
And
what do you call
yes, my lord. What
tacit consent or
yes, what I'm saying, my lord, page 183, their letter. This willingness, now this ground has come up, my lord. 183, this is the willingness only with regard to the excess land of helipad. You kindly have 183. There was no dispute as for the other land which were already in possession. The excess land which I have shown.
You have shown us the notification.
Yes.
That notification is
174.
174.
I'm sorry. The
no.
notification is at 175. Yes.
175 is the award.
Yes. 160.
My lord, if you notice.
281. I'm sorry. 281.
281.
Yes. 281. So 281. The chart is mentioned, Madam. So after this, my lord.
Just a moment.
Yes. After the notification, my lord, they write a letter 164. They say we want more land.
Then 8. वो बोल रहे हैं नहीं यहाँ पे ऐड करने के लिए it is requested that may be cancelled immediately without so and so during survey so and so so and so there is therefore requested in this instance the draft notification approved by area actual area as per approved state is as per the cancel फिर उन लोगों ने ये लेटर दिया 199 में लोगों ने कभी वो एलिमी का बारे में कुछ नहीं बोला एलिमी का बारे में कुछ नहीं बोला लेकिन वो 9,000 10, 11. 11 constitutionally. Hmm? 90. उसके बाद बड़े आपको मतलब 17 का वो गवर्नमेंट या कम्युनिटी लैंड ये आपको नहीं चाहिए कुछ भी सर्टिफिकेट अब वो जो एक लेटर जिसमें प्रूफ किया था कि ये मार्केट में इस्तेमाल करते हैं इतना लिटिल हो सकता है तो फिर सब सर्टिफिकेशन है हम दूसरे को
So special messenger, you'll have to get it by Tuesday, the records,
Original
original records.
from the deputy.
So once we apply a mind, there is no point adjourning it for a longer period. So everything falls apart otherwise.
Next week, Tuesday.
Next week, Tuesday.
Next Thursday is a holiday. Wednesday.
The original records, along with supplementary records, if any. The original language records, along with supplementary records, if any. Because we will require everything. Starting from the preliminaries with regard to social impact assessment, once you are doing under the right of fair compensation or exemption from social impact assessment, there will be documents for that also. Then again, what do you call this objection, if any, to the acquisition process, then preliminary survey. So these are, everything is time bound. And then section 19 declaration. So we are not saying everything. We're just mentioning in the order that this original land records with supplementary records, if any, regarding compliance of the provisions of Right to Fair Compensation Act. No, we'll say it. We are saying just the requirement of the act. We are not specifying. We may forget to mention one thing and then the records will not come.
By the time, your lordship, my friend brings those documents, my lord. Wednesday, I may be permitted to connect with VC, my lord, because that permission may be granted, my lord.
Okay.
Since I'm here today, my lord, I just, 5 minutes, may I just demonstrate as far as the willingness part is concerned, my lord. And the res judicata part, my lord, that part I have certain judgment, I will take 5 minutes, my lord. My lord, rest of the documents they may produce, my lord, because that is your lordship has
No,
to
because
satisfy.
we'll enter into merit also on that day.
That day. Reserve it for that day.
All right, all right.
These parts, whether for the additional, you can similarly in the. He proceed comes with 138.
138. What is that?
So the then it was passed in 2017, all those creations. Directly the deputy commissioner to Departmental office, this is the government level, it proceeds comes to be 138.
138.
Survey, those is the petitioners, they have activity they participated. And everything, the notification was, everything was done. In respect of that particular proceeding, what the activity has written to the deputy commissioner? See. Kindly refer to this office register and so regarding issue of allotment order of Alini, Malay, Alenai, Dumbe, Italy and native and influence. Refer your office to so by this letter to notification of meeting to so let it send to secretary lane land management government of Punjab. But after lapse of considerable time, no further progress is intimated by you, good office still there. Also refer director lane and so. The last important is hence you are again requested to speed up the process on this issue and the allotment order of so in the name of the IDs. So they participate in those acquisition processes.
You see, we can't jump into conclusions. They are saying that please allot the land. Allotment of land is with the presumption that it is a government land. If it is land to be acquired, then there cannot be an allotment. Then there can only be an land acquisition.
And and coming, if lawsuit comes page 137, 134.
134.
134 lawsuit, details of the property to be lawsuit.
Because you see, that makes sense. Because of the fact that,
134 lawsuit.
no, we're telling you, Mr. Tapin, you see, whatever the Mr. Kato is saying makes sense if we accept it that the land is a government land. Because then they proceed with on the premise that it's a government land, you allot the land to him. Then when it comes to acquisition, they say that now you restrain it, we want only this much and this much and this much. Earlier, they were holding much more larger chunk of land. Now they are restraining themselves to land when it comes to purchase. Purchase means land acquisition. Correct. Now,
What I am pointing out is,
yes,
though the determination was not there, the government treated it as a private land and acquisition proceeding was initiated. And petitioner lawsuit, they participated.
My lord, that may not be,
Exhibition lawsuit.
that may not be, my lord,
doesn't make sense.
my lord,
You see, land acquisition notification is at
24.
page 281.
Yes.
Correct. The date is important. It is 24/4/2018.
Published in 10th of May,
24
2018.
18. Published
10th May.
10/5/2018.
My lord, after that, on 6/6.
So therefore, this draft notification, which are of 2016-17,
So this is after the budget passed in 2017, where the deputy commissioner has been directed to determine also. After that order, this process was taken place. Where lawsuit, this property has been treated as a private land and acquisition proceeding have accelerated. Where the equally participated and consulted.
what is the date of judgment? 2017?
January, it's January 2017.
January 2017.
It's 18 January 2017. Because you let us go ahead. And now you can't turn back and say, "Look, we have not given the consent."
Your own officer has filed an affidavit.
Then, sir, that is whether determination was not there or not on this issue of this.
My lord,
But even if determination was not there,
He has spilled the entire milk.
My lord,
My lord.
that will be clear from page number 279,
my lord,
para 29. Page number 279, para 29.
Oh, these are parawise comments.
Yes.
Nobody is taking responsibility.
What will process, that judgment
You see, this is
delivered in
a,
the year 2017.
this
was-
is a parawise comment.
Yes.
Nobody is taking responsibility. That is why we expressed our annoyance to Mr. Kato that the document is coming to record without any affidavit to support it. Who will take the responsibility of watching for the correctness of a parawise comment given to a lawyer?
lawsuit 1.8. Lawsuit 1, page 134. Here, lawsuit, the event the statement has been lawsuit placed before the requiring authority.
yes.
Down below lawsuit ITBP. And this lawsuit letter,
You go further. There are documents which will show that the willingness certificate that was asked for was not given.
My lord,
that is there also. But what is the willingness certificate? It's a,
That's different.
yeah.
there's a kind of repetition. One is
My lord.
lawsuit, here it's written lawsuit to be speed up as a shown lawsuit.
My lord, once they are in possession, my lord,
It says lawsuit, we want this land.
they are saying that this is the extent of land in our possession. I mean, we are using it. They're not disputing it, my lord. And kindly have one letter, my lord, from them, page 183. And I have also shown, my lord, they wanted excess land. They are saying this is there, but you have not included this part, which is the helipad, 3 helipads.
We want anything, understand anything.
We get the.
Yes.
You see, this 134 is seeking an objection under section 48. 48 is the establishment of National Monitoring Committee of the Land Acquisition Act.
Also kindly have 183, my lord. 183.
183.
83. Yes. This is clarify, my lord, everything. May I just read it?
1.
83. Annexure, 83. This is from the battalion to the headquarter. May I read, Milord? This is the para-wise comparison of comments. Not for the read, their internal assessment, Milord. May I read, Milord? Para 1, serial number 1. Proposed land with a unit for forward post is more than the land taken in the estimate by the Revenue Department. The land taken over by the unit indicate for the helipad, while the area of the proposed land is larger, more than the authorization. Now, on the right-hand side, Milord, they say, Lordship has that. Remarks, in regard of 9 Battalion, request to Deputy Commissioner by letter dated so-and-so that the area of helipad of the said post should also be forwarded. In compliance above, it has been intimated by the Deputy Commissioner Anini that the helipad of both forward posts are at the Civil Department, so its area cannot be included. So these are the extra land which they are mentioning in 164. Say, we want this also, apart from what have been acquired. Now, Milord, kindly see, what they are raising, Milord, is the willingness. Next page. 184. Willingness is only with respect to this area. The willingness certificate is also not attached with the additional area of 730 square meter taking for helipad of the forward post, the Dunben. In this regard also, so this willingness has been now blown out of proportion, saying we have, when they are in possession, Milord, when they are saying this is the extent we want, award reflects mathematically exact figure, not an inch more, not an inch less. So what is the purpose of that willingness when they are in possession from 1955? So this willingness only with regard to the extra land they wanted. That was the case that point in time. Now this has been blown out of proportion. And circle officer also mentioned that it is for the additional land.
Well, when you are reading this willingness?
It's 0.4, 184.
184?
Yes. The willingness certificate is also not attached of the additional land of 730 square meter for the helipad, for the forward post. So this willingness, Milord, is totally.
Okay, we'll continue tomorrow. Because second half will not be, we will be rising for the single bench.
Very good.
Regarding the instruction, the first item number.
That records may not be required now with what
Mr.
Mr.
Vishwas.
Vishwas is showing us.
तो शाम को तो आ ही जाएगा, नहीं तो शाम को तो आ जाएगा, नीचे छोड़ दीजिए, शाम को भेज दो।
Other division bench matters would be rolled over. I think because.
इसी बीच में दे दीजिएगा, बेटा हुआ तो परसों से दादा से बात कर लिया, परसों से बात कर लेगा।
It will come up tomorrow. Grateful.
The argument of all sides remain inconclusive. List again on tomorrow. Thank you.
This is the
और दो आइटम बचा है, उसको नहीं करेंगे। कल के लिए बोला
वो अभी कौन सी था?
उसको 3 weeks कर दो।
वो भी हमको दे दिया।
हाँ
दीदी का बच्चा कुच्चा का कब बोल रहा है? कल मत कीजिए, एक हफ्ते का बात कर दो। आफ्टर 1 वीक कर दो। हेलेन वेले दीदी। हाँ 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 7 को 1 वीक आफ्टर कर दो ना। नहीं होगा 14 में उन लोग की है क्या?
ये
ब्रेक हो गया, चला ब्रेक।
ये किसका है?
दीदी खत्म हो गया वो है। साइलेंट वैली
उसको 1 week बोलेगा आफ्टर 1 week। लगी बोल रहा है आफ्टर 1 week फिक्स करा बोलते।
Filing an additional affidavit therein. So I'm seeking some accommodation from a lordship. And item number 24, we have filed an affidavit today itself, lordship. So that also has to come on record. So I'm praying in both the matters if it can come on 7th of June, lordship.
14th,
Item number 15 and 24.
15 and 24.
Yes, your lordship.
Okay. Other side is here.
Other side is the government, lordship. There's no interim order.
Fifteen and 24. You're for the
15
peti-
and
You're for the petitioner.
I'm for the petitioner. Yes, your lordship.
Okay. Separate orders. The clear made by land council for the petitioner list on
7th of June.
7/6/2024 along with affidavit,
Yes, lordship. To file additional affidavit.
if any filed.
Yes, your lordship.
Okay.
Oblige, lordship.
My lord, I beg to mention WFC number 435 of AB 2019. Since that petitioner has engaged me
Wait for
to.
listing, give it to the court master. They will have to make some adjustments. It
My
will
lord.
not come on the day you are wanting.
My lord,
Give it to the court master.
my lord, this matter is pertaining to LPC matter. So the petitioner don't want to pursue the
We'll have to
matter.
make some adjustments.
Okay.
Your Lordship, I beg to mention item number 3.
Item
Item number 3.
3.
I'm for respondent number 3. Your Lordship, the counsel is not available as he is not well, so I pray that Your Lordship may kindly list the matter on the 5th of June, Your Lordship. I have taken consent from the.
Okay.
I'm for the petitioner.
Both sides are represented. List on 5th of June.
5th of June.
5th of June 2024 as paid for by land council for respondent number 3. Yes.
Your Lordship, also for item 11 and 12. If the same, it can be listed on the 5th of June, Your Lordship.
Lordship, I am for the petitioner. So the matter may be fixed for 5th of August. As per last order today,
5th
interim
of
was-
August.
oh, sorry, 5th of June. 5th of June, next month.
I'm for respondent number 6, Your Lordship.
Okay, item 11, same. All sides are represented.
On the next day, the interim may be heard because as per last order.
You're for respondent number?
6.
Respondent number 6.
Yes, as per last order, our interim prayer was supposed to be considered today, but they have requested us to accommodate them. So on the next day,
Okay, prayer for interim relief shall be considered on the next date of listing.
Your Lordship, for item number 6 also, Your Lordship. Item number 6. 6 and 7, Your Lordship.
You taken consent of the other side?
Yes,
Yeah, yeah.
I am for the petitioner.
If this matter may kindly be listed on the 6th, Your Lordship, 6th of June. Both item number 6 and 7. In item number 6, I'm appearing for respondent number 9 and 10, Your Lordship.
6.
And in item number 7, I'm appearing for respondent number 2.
Also is a representative of here made this one, sir. List on 5, 6,
6th of June, Your Lordship.
Huh?
6th of June.
6 is a Thursday, no. 5th,
Then my lord, 7.
7. Okay. 7, 6.
My chawla. But please, your lordship. Lordship, I beg to mention item number 26.
26.
Yes, lordship. Lordship, conducting counsel for the petitioner, Mr. Pangin, has gone down to Guwahati for his daughter's admission. So kindly this matter may be fixed on 10th of June, lordship.
You have informed the other side?
Yes, lordship.
Okay. Also is a representative on the prayer made by land council for the petitioner. List on 10, 6, 2024.
50 of license.
Well, in this case, that one Velacha Engineering Limited, that he was the successful bidder in respect of two packages, package 2 and package 3 of a road construction project, Tato Mesoka Road. Now, we are in the present the petition, we are concerned with the package 2. And under the agreement, contract agreement, there is a provision for granting the subcontract. Accordingly, to the extent of 49%, the subcontractor was the subcontracted to the present petitioner, and accordingly he has been executing the work. And in spite of many odds, he has completed the extent of 49%. In the meantime, because
In
of
your
the
original
delay,
contract, what is the time for contract? Completion of the contract?
time for completion of was 3 years, but these contracts have been terminated.
It's okay. What is the term? What is the tenure within which you should do the work?
Page 35 is the LOA.
Just give me the time.
Rajam. It was for 3 years. Perhaps.
You see, the only concern of yours is for pendency of the bill.
Bill. Yes.
So we can't stop the fresh contract, fresh tender.
No, let this what happened, my lord, here, the contract ultimately has been terminated. And there also, my lord, there is a clause, my lord, for taking the, my lord, valuation of the work executed by the, my lord, person concerned and for payment of the termination payment.
Yes.
So that is one of the clause, but that has not been done. Now, initially, my lord, on 11/3/2024, a fresh tender has been my lord, floated, giving the same portion of the length.
You see, that's the reason. Come to page 106 and 107. There the court says that you may go ahead with the NIT. So therefore, now you can't challenge that NIT.
This is the last one, my lord. Initially there was on 11/3 and subsequently, my lord, this has been, my lord, published. This is the present one is there, my lord. Here, my lord, this so far as the work executed by me, that has not been, my lord, valued, nor it has been, my lord, reduced from this length of the portion of the work, my lord. And the valuation, your lordship will find initially this length was for 80 crores. And admittedly, my lord, according to me, I have completed 49%. Admittedly, from them, the BRO has admitted to the extent of 21%. If this 21% is, my lord, valued, it comes to about 17 crores. But then, my lord, what they have done, the entire amount has been.
What is the nature of work you have done so far?
Road construction, my lord, I have completed, my lord, 49% of the available, my lord, scope of work. Lordship will kindly see, my lord, the termination order, my lord, at page 77.
You see, when it's a construction of road.
Yes, yes.
Let us say that, let us presume that this is a road.
Lordship.
Correct. You have done this much.
Lordship.
And now this is remaining.
Yes.
So you are saying that the contract is issued for all this entire, correct?
Present NIT.
Now, do you undertake before this court to do maintenance work for this, for the entire work period? Maintenance you are not doing.
No.
So therefore, a contractor who has not received this payment for this cannot do maintenance for this part.
The contract, well, the moment the contract was terminated, the site has to be handed over to them.
Understand? But there's always a maintenance period for a contract
Yes,
work.
yes.
Now, who does the maintenance for this?
My lord, perhaps no one is doing the maintenance because I have been ousted. Neither the principal contractor is doing.
Let it continue. We are not stopping with the work. We're just issuing notice.
No, lordship will kindly see.
Tender, we are not staying.
No, I am not praying for stay of the tender, my lord. At least the final, my lord, the results shall not be declared because in the other petition.
No. Let them go. Your requirement is only that payment of the work.
My lord, once the tender is finalized, the new tender, my lord, is given possession of the, my lord, work site. My lord, the very evidence of mine, my lord, that will be wiped out. And in fact, your lordship will kindly see, my lord, this on 16/5/2000.
You see, this court had allowed the NIT to go. Therefore, we are not interfering with that order. 106 and 7. Court said proceed with the NIT.
So they may proceed. Finalize the contract. No. Your lordship will kindly see this order, my lord. On 16/5, this court has passed an order directing them to, my lord, have the joint valuation, my lord, within a period of 3 weeks, my lord.
Yes. You have instructions on that.
This has been done, my lord. This order in favor of this petitioner that has been passed on 16/5. Now, so far as the tender is concerned, I have already, my lord, stated that the entire work has been put into the new tender. Now, until this joint verification is done, and the, my lord, in the meantime, if the tender is settled, in that case, my lord, the person who will be, my lord, entering into the contract, my lord, he'll just simply have to submit the bills because the works, my lord, to the extent of 49% has already been executed. It is not in the public interest also, my lord. The total value is, my lord, 80 crores, my lord, initially, my lord, that was floated, and subsequently now it is, my lord, 79.5 crores, my lord. And whereas admittedly, my lord, I have done, my lord, 17 crores and not. So this is also not, my lord, in the public interest, public money, my lord, that is already, my lord, involved there, my lord. And similarly, my lord, in respect of the another the package 3, same fact, my lord, at page, your lordship will find at page, my lord, 105. Tender has not been
You do
stated.
verification.
My lord.
Work has to be verified.
Work has to be verified, my lord.
So with past similar orders is given here.
My lord, this is in my favor, already has been passed. Now, if, my lord, during pendency of this joint verification, if the tender is finalized, before, my lord, this joint verification can be done. In that case, my lord, I will suffer again, my lord, even this order
No, you
would
keep a
not be
track
able
of,
to.
you keep a video photography of what you have done. If they don't do it, but still they will go ahead. Tender, so you're not staying.
My lord,
You permit them to
can
keep
you-
videography of what work they have done unless you verify. You do it within.
My lord,
2
the other
weeks.
difficulty is,
valuation-
my lord, the original contractor is Malaysia, my lord. He was the subcontractor, my lord. And even if, my lord, the joint verification is to be done, my lord, it has to be done by, with the, my lord, the Malaysia, the principal.
You give a notice and do it alone. You're normally a contract agreement permits that. If they don't come, what will you do? Let us presume that the contractor will not come. Then what will you do?
That's what is happening, my lord.
Tell me what you will do.
My lord, this has been provided in the, my lord, contract clause also, my lord, I have submitted that.
My lord, this is the notice may be issued, my lord, will come with the.
No, you do it. You do your verification within 2 weeks. We also permit him to do the videography of his work. If you don't do it within 2
My lord, the
weeks,
procedure has been
this will-
prescribed, my lord, how the verification has to be done. My lord, it is not that, my lord, the detailed
Regarding the
procedure has been my lord, done.
No,
my
if
lord.
they don't do what, then what you will do?
But therefore, this court has directed them
No,
to
no.
do it, my lord.
We are also directing, but we are not staying any process.
My lord.
My lord, I am just on, my lord, not to finalize the, my lord, the tender process,
No.
my lord, before the joint verification.
No, that we are not doing. Not at your instance.
My lord, can you see, my lord, the same, my lord, matter, my lord. The order has been, my lord, the similar order has been passed. I am just praying for a similar order, my lord, at page 106.
Contract work, we are not staying at no cost.
No, not the contract has, my lord, the tender has not to be stayed, my lord. Tender is not to be stayed. The final order may not be, my lord, made, my lord.
Let us presume that for 6 months they don't do it. Then what? We are stopping a development work.
My lord,
that we are not going to do.
My lord, the development work, my lord, definitely, my lord, but it is an admitted position that I have executed to the extent of 21, according to them. I said, my lord, I have done to the extent of 49%. So therefore, the court having been
therefore,
satisfied, directed them to, my
claim
lord,
is quantified. You see, once a claim is quantified, then you're not entitled to a stay, because it's anything which is due to you is quantifiable in terms of money.
So therefore, to quantify, my lord, this joint verification is necessary in terms of
give
the
a direction to them to
contract
do
agreement, my lord.
We'll give it my direction, but I'm not staying anything.
But that direction is already there, my lord. That is the order in my favor. This particular order I have just given to you, lordship. But in respect of the package 3, your lordship will kindly see, my lord, page 106, my lord.
One zero six.
106 million. That is in respect of my package 3. The last minute paragraph, accordingly, having heard this submission made by body learned council, this court find it.
That's what we are saying. 106 and 107, the court says the tender should go ahead.
Yes, madam. Tender should, only not to finalize, madam. That's what, that is the word. NIT dated, but shall not finalize the tender process till the dispute
No,
of
we
the
are not-
instant
we are
revision.
not
Now,
doing
madam,
it.
what I am
It's a-
submitting, madam.
it's a stay operating.
Madam, till the madam, joint verification is done, my lord. At least that much, my lord, till done, my lord. And the dates are, your lordship will kindly see, my lord, the last date of my lord, technical.
Are you prepared to give a security of 20 crore?
My lord, time
What is the value of work? What is the value of this tender?
My lord, the original value
No, this tender is how much? The present NIT is how much?
My lord, this is a my lord, tender, my lord, joining two package, 2 and 3.
What is the value?
Value is 133 point, 19 CR.
So 20% security, 26 crore you deposit. You'll
Lordship,
stay it for 2 weeks.
Can you see, my lord, the tender notice you also will find, my lord?
Mr. Saikia, development work for the roads in the
No,
or any development
my lord, the
project.
time is still there, my lord. The tender notice will also be the technical bid to be opened on 30th of May. The financial date of opening of the financial bid has not yet finalized. Thereafter, my lord, the work, my lord, will be, my lord, necessary formalities are there. So in the meantime, this court has already, my lord, directed them to, my lord, have a joint verification within a period of 3 weeks.
We are permitting you more than that.
My lord, my
We are
submission
permitting-
is that
we are permitting you more than that. We are saying that they will either do it in 2 weeks or you will do it unilaterally. So we are permitting you to do it. The verification of the work which you have done, if they don't cooperate, they don't do it within 2 weeks, joint verification, then you do it. You go unilaterally, do it. And that will be by the order of the court. You got no grievance.
my lord, the tender, my lord, as per the clauses, my lord, it is there the procedure how the joint verification. And it is not, my lord, in
But
the package three, they have done it, my lord.
Do you say that the High Court has no power to give a direction to do it within a particular time?
No, that's what is given, 3 weeks given, Lordship may reduce it to 2 weeks, my lord, but then, till then, my lord,
I'm
this
not
final,
saying
my
it.
lord, 30th,
I am not staying it at no cost.
my lord, here, my lord,
Unless you
the-
deposit 20%, we will be gladly staying it.
my lord, my claim, my lord, I have been suffering, my lord, I have annexed the documents, the banks are, my lord, pressing hard for.
Computable in terms of money. We are not staying it at no cost.
But at least this observation, my lord, till the joint verification is done, at least, my lord, this should not be finalized. My lord, if they do it, my lord, within a week, my lord, fine, they can go ahead, even if it is,
No.
my lord, done before 30th. Or Lordship may put it by, before 30th, they'll be doing it, my lord. 30th is the date for, my lord, opening of the technical bid. Thereafter, my lord, the tender committee will sit and this will be approved.
No stay. Stay, I'm not granting at no cost.
But I'm not praying for a stay of the tender, my lord.
It's same thing.
It's
If I
not-
say don't finalize, it's a stay.
My lord, only the,
It's a-
my lord,
it's a-
this takes a long time, my lord. This takes a long time. After the technical bill, technical committee will sit and they will evaluate, then it will be, have a, my lord, approval from the competent authority. Then financial bid, then again there will be an approval. Let them have the joint verification by 30th of, my lord, the May, my lord.
What is the case law on the non-granting of stay on development works? What is
Sir, that is there, my lord, NG project.
Which is
NG project, my lord. That is there, my lord.
You'll have to convince. You'll have to convince there.
No, my lord, subsequently, my lord, in the case of my lord Bhulanath, my lord, this
No.
NG project has been, my lord, distinguished. Now here your lordship is the manner they are doing, my lord, the initial contract is for 80 crores. I have done 21%, that comes to about
Mr.
17
Saikia,
crores.
Please tell me, when the court is permitting you to do a unilateral exercise of videographing your work,
Yes.
what more do you want?
Yes, my lord, subject to his agreement, my lord, yes.
You just need an evidence.
Yes.
What happens if you file a writ petition for your money? They say that you have not done the work. You can show the videographer and tell us that this is the work done.
Yes.
Do it.
My lord, his
They
consent may also be recorded in that case because
Why consent?
others they'll be disputing that. which
I'm
is
not passing
done.
a Gaungura order where there's a consent, there's a panchayat where we are settling matters, both sides are agreeing to it. We are not doing that. We are passing an order of the court. It's not a panchayat exercise. Why should we hear him?
I'm not submitting before Panchayat court.
No.
also.
So therefore, we are not taking his consent. He may not give a
My lord,
consent.
very tender itself is not in public interest. I am saying, my lord, because my lord, the value, my lord, out of 80 crores, my lord, 20 crores have already been executed, admitted by them. Still, the tender is for 80 crores. Lordship will clearly see what is the, my lord, game plan. They have the authority, my lord, with the new tenderer who may come in, my lord. 20 crores work has already been done, and that is shown that you have to execute this work. They'll just submit the bills.
That was the first question asked to you.
Lordship.
That was the first question asked to you. You file an affidavit that for the 20 crore rupees work you have done, you will do the maintenance during the maintenance free period. You file an affidavit tomorrow, we'll take it up. Please tell me, Mr. Saikia, you two are contractors. He does 20 crore rupees. his tender is cancelled. Now you get a tender for same amount of work at 80 crore. Now, his work of 20 crore, are you willing to do maintenance work? That is the first question we asked you. And therefore, even if they don't do a work, but they will say that we'll take the entire work and then we'll do the maintenance.
These all are attached to the principal contractor. My approval, your lordship may kindly see, my lord, I have.
We are only a subcontractor.
Well, I am the subcontractor. My lord. I am not the principal contractor. All the damages, whatever that is to be, my lord,
So therefore,
be levied
what
on
interest
the
do you have in
contractor.
staying it? What interest do you have in staying in delaying the finalization of contract?
No, my whole interest is that joint verification should be done as per the terms of the contract.
Look at the order.
That is
Get the
thing,
order.
and that order has already been passed.
We hear the order. Heard Mr. P. J. Saikar and senior counsel, assisted by Mr. K. J. Saikar and counsel for the petitioner, and Mr. M. Katolaner, CEC appearing for the respondents. Number
All
numbers
respondents.
1 to 5. All the respondents. The respondent authorities had issued LOA dated 7/6/2021 for construction and upgradation of Tato TATO dash Mechuka MECHUKA road. This you'll find in the synopsis. Is a long one. I'm putting a flag. Full stop. The petitioner projects that they were they were approved as a subcontractor for 49% of the value of contract by letter dated 10/12/2021 issued by the respondent number 3. Full stop. The petitioner claims to have done a substantial part of the work. Full stop. However, the respondent authorities had cancelled the contract what is the date of cancellation of contract?
Termination of 16/12/23.
Termination of had issued the respondent authority had issued a notice intending termination dated 7/2/2023. And after reply submitted by the concerned contractor, where is that? Notice of termination in your list of dates. Where is
Page 77.
that? 7. Where?
Page 77 is starts.
77.
Page 77.
The notice of termination dated 16/12/2023. They were terminating the contract agreement with the concerned contractor.
In paragraph 13, my lord, that's what I have been highlighting, my lord, in the termination order, my lord, at page 84.
Para?
Para 13, page 84.
84.
84. fourth line onwards. my lord. Page 14 also, paragraph 14 also, page 85. The main contractor did not pay me, therefore, my lord, that is also admitted there. Paragraph 14. And consequence of termination, my lord,
Referring to paragraph 13 of the termination notice. It is submitted that the respondent authorities have admitted overall physical progress of the work to be 21.72% done by the subcontractor, i.e. the petitioner. Full stop.
and consequence
Accordingly-
upon termination, my lord, clause 24, my lord. 24 and 26. Valuation of the unpaid work under clause 23.5.
First of the said termination letter also provides for valuation of unpaid work to be carried out as per clause 23.5 of the contract agreement. Full stop. The next paragraph, the petitioner approached this court by filing a writ petition being WPC 3 within bracket capital A of 2020 3A.
Prachun.
3A.
3 AP.
The petition here is registered as 3A.
3 AP.
No, my lord, it's only 3, my lord.
Huh?
3,
Only 3.
only 3, my lord.
3 of 2024. And in connection with IA Civil 24 or 24 arising out of the said writ petition, this court by order dated 22/4/2024 directed the authorities to conduct a joint verification of the work within 3 weeks with a further direction not to finalize the tender process till the disposal of the said writ petition. Next paragraph. However, the respondent authorities have issued a fresh NIB dated 1/5/2024 for the balance work on combined package Roman 2 and package Roman 3 at an estimated cost of rupees 133.19 crore. So accordingly, the petitioner has filed the present writ petition. To challenge the NIT dated 1/5/2024 and for a direction to the respondent authorities to conduct a joint verification of the work. The petitioner has also prayed for an interim relief.
My lord, the joint verification order in my favor has already been passed by this court, my lord.
An interim relief for staying of the tender dated 1/5/2024. Next paragraph. Issue notice returnable on. This should be here. This, the other matter is listed today. First. This repetition, when it is listed,
First time,
165.
165, it was, order is dated 22/4/2024.
Listed when?
First time, the order is on 22/4/2024 in 165 and
Yes.
page 105,
No, this is to be listed on 20.
the present one.
Today's
Today's 20th,
28 is listed today, no?
not listed, my lord.
It's not listed. Renewable on. How much time? 2 weeks.
Since it is in bordering to the China, so 3 weeks time will be granted. In other cases also.
No, they are to do the verification of the work that has to be done within 3 weeks.
Within a free.
Last matter was ordered to be listed on 20, that is today. You must have done that exercise.
Yes, they have done it.
In
The
respect of,
other petition, they have done it.
so therefore, my lord, we are going to file the IA for the modification
After
of
the
this
court's
order.
order, they have
We have
done
already gained that matter.
So this is which package?
This is package 2.
And this repetition was page 106. This is for package.
This is for package 2. The 165 is for package 3.
Oh, then don't write that. Don't write about repetition. You strike out that. The petitioner approaches this court. Strike out from there. This is a different petition. Okay, the notice is made returnable. On, give a date after 3 weeks. You're listing it on the 3rd of June.
3rd of June.
On 3/6/2024. So the respondent authorities are directed to measure the works which has already been done by the petitioner within the set period for which the petitioner shall also provide all necessary assistance. Full stop. The court also permits the petitioner to take a videograph of whatever works they claim to have done and provide a copy thereof to the, who is the authority? Chief engineer. To chief engineer, project Brahmank, BRAHMANK, prior to the next date of listing. Full stop.
May I interrupt?
Next, brother. Although the learned counsel for the senior counsel for the petitioner has prayed that the tender process should not be finalized, comma, but having taken note of the contents of the termination notice where the concerned respondent authorities have valued the physical progress of the work carried out by the subcontractor as 21.72%. And having regard to the fact that this court had also directed a joint verification to be made within the 3 weeks time allowed, and alternatively permitted the petitioner to make videography of the work done, comma, the court is not inclined to pass any interim order which should have the effect of delaying the finalization of the NIT issued on 1/5/2024. Was published on
on
3/6/2024. Yes.
So first, my lord, I have given the order copy, my lord, that is order dated 16/5.
Yes.
This court has already, my lord, directed the authority to have the joint verification within a period of 3 weeks. That is the order, my lord, I have already submitted to your lordship.
186.
186. my lord.
This is with regard to
Some petition, package 2.
package 2. Now you are saying this is package 3.
This is package 2.
No, earlier petition you said was package 2, and this you said was 3.
So far as the, my lord, the order at page 105 is with regard to the package 3.
Oh, this is different.
This is package 2, is filed by me. And there this court has already directed to have a, my lord, joint verification within a period of 3 weeks.
That
So
is already
now,
done.
my lord, they having been, my lord, floated the tender, my whole submission that till this joint verification is not done, at least this should not be finalized, because the date of opening of the technical bid on 35, thereafter financial bid, etc., my lord, many stages are there, but they may take long time. Therefore, my lord, I am submitting, my lord.
Okay, I'll make that necessary correction. Okay. I'll make that necessary correction.
My lord,
Let that order be typed, I'll make necessary correction. 186.
186.
I'll take note of 186.
Well, that is in respect of me, my lord. That is so.
I'll make that correction.
So far as package 3 is concerned, there are also similar order for joint verification, and thereafter an order was passed, but saying
So
that
186 is package 2.
186 is package 2.
Okay, I'll take note of it. Let the order be typed.
Same
I'll do the
petition.
necessary correction.
Same petition.
I'll do the necessary correction.
That's right. And so far as the order at 105, it is in respect of package 3.
Okay. Okay, I'll take note of that. I'll make the necessary correction.
My only idea is that before verification at least should not be finalized. Otherwise, from the date, it will not be my lord stayed. But it is not my lord.
We are permitting you photography.
My lord.
We are permitting you to do the photography.
Lord.
That will constitute a proof. Yes.
Lord, very briefly, I'll just present the facts.
That's why we are issuing a notice here.
Law is settled.
I know that.
There cannot be second inquiry. And Supreme Court, in fact, has laid off the scope. Unless and until it is the case where some very new evidence, some evidence was there, it was not even produced. Some very vital aspect was missing absolutely. It has come to their notice. But in this case, so far as 31 is concerned.
18.4, where is the order? 18.4?
18.4. The 18.4 order, my lord, will find It is at page 44. Now, my lord, so far as the first page is
We will
concerned,
state for the time being.
it's a recital.
Till next date, we are staying this.
In fact, my lord, we'll
Very
skip
well
page
done.
45. I'll just point out how arbitrary the whole thing is.
It's okay, we are
So
staying
very
for
well.
the time being.
Or whether, my lord, should I show the judgments on the subject?
No, not
Very
yet, not at this stage.
दिया हुआ वहां से।
Mr.
कल
P.K.
भी-
Tiwari, Senior Counsel, learned Senior Counsel, assisted by Mr. K. Saxena, Counsel for the petitioner, and Mr. S. Tapin Lalan. Additional Senior Government Advocate appearing for all the respondents.
All the rest. Three respondents.
The impugn order dated 18/4/2024, directing a de novo departmental inquiry against the petitioner is under challenge in this petition filed under Article 226 of the Constitution of India. Issue notice, including notice on the prayer for interim relief, returnable on how much time?
4 weeks.
It's in 4 weeks. First of- As the learned Senior Government Advocate accepts notice on behalf of all the respondents, formal notice is dispensed with. Mr. Howard, requisite extra copies of the writ petition be served on him in course of the day. Next para. Till the next.
My lord, tomorrow we'll give the copies. Tomorrow we'll give the
Okay,
copies.
within 2 days. As an interim measure until the next returnable date, the operation of the order under memo number, page 45. So and so dated 18/4/2024 shall remain stayed. Yes.
May I please your lordship?
Yes.
Lordship, in the last occasion, lordship, there is a standing order. Lordship may kindly peruse order dated 25/4/2024, lordship. In this very order, lordship, the respondent was directed to file their affidavit, lordship. And if they fail to file their affidavits, lordship, whatever it's in the pleading, the lordship will go in disposing the matter, lordship. That was the opinion of this honorable court, lordship. So, lordship, I will insist that this matter may be disposed of, lordship, if they fail to file their affidavit today, lordship.
Okay. Yes, what is your stand?
Lordship, I am for respondent number 7 and 8, Deputy Commissioner. Here also, Lordship, union is the main party here, Lordship. Though we have not filed our affidavit, Lordship.
Yes, Union of India who is appearing.
They are the main party here, Lordship.
Yes, you're not filing an affidavit.
I have not received any instruction from the department, so.
This is item number.
4, lordship.
Yes.
Well, my afraid that another chance may be given so that the affidavit can be filed.
No, if you're not receiving anything, you see, there's an order of the court making an endeavor to dispose it off.
I'm sorry, my lord.
Lordship, in fact, there is 2 orders, lordship. Lordship may kindly see order dated 4/1/2024 also, lordship. Same similar order, lordship. Again, opportunity was given, lordship. This was the last opportunity that was given, lordship. 25/4/2024.
In such cases, Mr. Jenny will give them chance, opportunity after opportunity. We are not paying the petitioners 4 crore rupees without any compelling the respondents to file their affidavit. So we are asking for the personal appearance of the officers if they are not willing to give you instructions.
Lordship. Lordship, the lane was acquired way back in 2014 itself, Lord, 2015
No, whatever
itself,
we
Lord.
got, we are not giving our.
Well, I'm sorry, my lord,
taken
one more
out of
chance maybe.
More than 4 crore rupees on a platter without compelling the respondents to file an affidavit. So we are calling your
My lord,
respondent number 2, 3, 4, and 5. next
my lord,
day.
may I pray that one more chance maybe
No,
granted,
no,
my
no.
lord. In the meantime, my lord, they'll come
No,
with
no,
the affidavit,
you
my lord.
look, you hear the order. Heard Mr. K.
J. Gini,
Gini, learned, J. Gini, learned counsel for the petitioners. Mr. M. Kato, learned CTC, prays for one further opportunity on behalf of respondent numbers 1 to 5 to file affidavit in opposition in the matter. First of Mr. G. Atel and additional senior government advocate submits that
7 and 8.
no for 6 for 6 is Mr. D. Kamduk and standing counsel for respondent 6 as well as Ms. G. Atel and additional senior government advocate appearing for respondent number 7 and 8 submits that they have but you're not filing an opposition here. They'll not be filing their affidavit in opposition in the matter.
My lord, since the other respondents are also not filing affidavit, my lord, one more chance maybe granted, my lord, so that I can, my lord.
No, we are giving you, but look at the order. You hear the order first. Next one. This court by order dated 4/1/2024 had made it clear that if the respondents do not file their counter affidavits as permitted, the court may proceed for hearing on the basis of materials available on record. First of all, the same view was expressed in the order dated 25/4/2024. First of all, however, the respondent numbers 1 to 5, despite orders dated orders passed on 4/1/2024 and 25/4/2024 have not filed their affidavit in opposition. Full stop. Taking note of the fact that compensation of a sum of rupees 4,63,29,954 has been assessed and approved by the state government, out of which a sum of rupees 82,18,029.30 has been assessed against the land, the court is inclined to direct the Director General of Border Roads, within bracket, respondent number 2, Chief Engineer, Project Udayak, within bracket, respondent number 3, the Commander, 48 Border Road Task Force, within bracket, respondent number 4, and the Officer Commanding, 1446 BCC, within bracket, respondent number 5, to be personally present before this court with all relevant documents on 3/6/2024. Full stop. Sorry, unless an affidavit in opposition is filed at least 1 day prior to the next date of listing. Full stop. If the affidavit is filed, personal appearance would be dispensed with.
Well,
shall remain dispensed with. Next, list on 3/6/2024.
Deep Development.
Next, the WCDC shall send a downloaded copy of this order to the respondent authorities for compliance. List on, after this list on. Sir.
Deeply obliged.
Obliged, Lordship.
May I play, my lord? My lord, this matter relates to suspension of Public Service Commission member.
But after what is happening, what is wrong?
Yes, my lord, the issue was that suspension has to be done after the reference is received by the Supreme Court. But in this case, before the reference was sent to the Supreme Court, and then before the receipt of the reference by the Supreme Court, the suspension was done prior to the reference under Article 317 sub clause 1. They can suspend under section Article 307 sub clause 2, but then after the reference received by the Supreme Court. So that is that's what we are praying for the revocation of suspension order, my lord. We have filed the rejoinder, my lord. I'll just take to the rejoinder, my lord. I will take to the important reference was received by the Supreme Court on 21st July. In my rejoinder, I have filed the reply that the reference has to be under Order 43 of Supreme Court Rule 2013.
Yes.
And that was received only on 21st July 2023, and suspension was done. Suspension was done prior to on 15 June 2023. Your Lordship may see the page, my rejoinder page 16.
But once the Supreme Court has made a reference,
yes.
So the order of suspension would stand ratified post facto, because you see, ultimately, whatever will be the ground, but the Supreme Court has got a reference. So once the Supreme Court is in session of the matter, on the presidential reference being made, this court would not make an endeavor to quash it and render the proceedings of the Supreme Court open to question. Sorry, the proceeding of this court to be open to question by the Supreme Court.
But my lord, my prayer is that suspension order itself is illegal. That is my prayer, my lord. When the suspension order, it can be suspension after the impugn order is set aside. They can take another action, my lord. But then the action has to be should have been done under Order 43, Rule 1 and 2 of 2013, where it says, my lord, we have enclosed that rule, my lord. Your Lordship may see the rule. Rule is, Lordship may see page 95 to 97.
Yes.
95, may I read?
Yes,
95.
you see that.
May I read page 96? Last para, last is Order 43. May I read? On receipt by the Register of Reference, page 96, may I read? On receipt by the Register of Reference from the President under Article 317(1) of the Constitution or any statute, or from the Governor under any statute, reference to the court, ground for the inquiry, it shall be registered in the register maintained for the purpose, and number are the reference number. It has to be, reference number has to be registered. But then the suspension was prior to that.
Correct. Where does it say that you see, how does the government, how will the government, appropriate government know that the reference sent to the Supreme Court by the, you see, number one, the reference is being sent by the President of India. Correct. Nobody in the state government will know when the honorable president will send the reference. Number two, the receipt of reference by the Supreme Court and registration of it. You think there's anybody in the state government to monitor that? And then arrive at the conclusion that now, yes, today at 10:30 the reference is registered. Now at 10:45 we are suspending you. Can that be the?
There should be a communication. There is a communication with the Ministry
President
of.
would not communicate to the state Public Service Commission. At least we are not expecting it.
But the constitutional provision, it said that only receipt of the report of reference.
That will be registered in the Supreme Court. Doesn't say that suspension is subject to the reference received and registered by the Supreme Court. What
They
does
should
it
have,
say?
my lord, they should have waited for the reference order from Supreme Court.
This shows from the rules that the suspension is subject to the registration of the 317 reference under by the Supreme Court.
My lord, 95, 97, that's what.
Please read.
95, 97, that's.
Please read that. You see, Supreme Court will make a rule about their own registration and progress of the suit. It will not say, it will not control what the competent authorities in the state government will do or the central government will do in ordering the suspension.
Because, my lord, Article 317 subclause says, my lord, clause says, my lord, well, I'll just take to my region, may I read?
See, you forget the Supreme Court for the time being. Correct. Now let us assume that this relates to the jurisdiction of the High Court. Now the reference will be registered by the High Court. Let us presume. I'm giving a very worst example, but the reference is registered in the Guwahati High Court.
Yes.
Now you want to say that the competent authority who is wanting to suspend somebody can do it only after the reference is registered here.
Yes.
No, not acceptable.
Article 17, my lord.
You read whatever you want to read. 317, I don't find anything saying that without registration of a reference, the officer can't be APSC officer or the APPSC officer can't be suspended.
My lord, in fact, we need not trouble ourselves. Reference was made by the president on 18th April 2023. After the reference was made to the Supreme Court, she was suspended on 15th of June 2023. Simple. The facts should be clear.
But the reference.
High Court will not say. You see, High Court, you just think of the order. High Court saying that the president, while making a reference under 317, shall communicate to all the competent authorities that the reference has been sent. And then we say that the Supreme Court is also expected that after registration, all the competent authorities will be informed about its registration so that the person can be suspended. This is the language I'll use in my order.
My lord, Article 317 subclause says that order on the receipt of report of the Supreme Court.
No, that's okay. I'm just hearing my order. I'm just hearing my order. After having dictated the order, I am now reading it again. Now, this is the order which I am passing. So I'll also guide the president how to act. And number two, I'll also issue a direction on the Supreme Court how to act. You think that is within my domain? At least thank you for thinking so. I can at least thank you.
In fact,
no, you're dismissing a writ petition.
I'm trying to convince is that Articles 217 said.
No, I've got it. I've got it, but I'm dismissing it. I don't want to be author of that order.
Article 317 also is very clear. After the reference is made to the by the president, the governor can suspend.
My lord, may I read Articles 317?
Yes. Keep this constitution in CPC. Yeah?
Article 317 subclause of the Constitution provides.
Please read it. Please read it. I have done it.
That president, in case of Union Commission or the Joint Commission, and the governor, in case of State Commission, may suspend from the office of chairman or any members of the commission in respect of whom a reference has been made to the Supreme Court under clause 1 until president has passed the order on receipt of the report of the Supreme Court on such reference.
No, Mr. Mo, we are dismissing it. Heard Mr. S. Mohan, counsel for the petitioner, as well as Mr. M. Ratan, and CGC appearing for the,
No, my lord, I am the additional agent.
as an additional advocate general appearing for
Oh.
the
One,
respondent
1 to 4.
numbers
1 to 4.
1 to 4. And CGC, you are the Mr. M. Kato, and CGC appearing for respondent numbers 5, 5 and 6. You are DSGI?
Yes.
DSGI, yeah? That's correct. The petitioner is a member of the Arunachal Pradesh Public Service Commission, within bracket APPSC for short. Full stop. Following an allegation of paper leak of AE within bracket civil bracket close mains examination held on 26 and 27 August 2022, the President of India had made a reference to the Supreme Court of India and Article 317 within bracket 1 of the Constitution of India. Full stop. It is projected that the reference by the President of India was issued on, yes,
18/4/2023.
18/4/2023.
My lord, will find it
and the
in the additional affidavit. Affidavit in reply, my lord.
And the reference was registered before the Supreme Court of India on when, Mr. Mo?
Yes. I also may see 20 is in page 16 of my agenda.
Just give me the date.
Reference number 1 of 2023.
The reference was registered, the reference being reference number 1 of 2023.
Oh, my lord, that is the report, my lord, office report, my lord. It is not the registration.
It's mentioned.
Where is that?
Top, my lord. Reference number 1 of 2023.
Office report with regard to, that is the office report.
You are reading page?
No, that is in the, it is region.
My agenda is in page 16.
Page 16. There is another, with regard to the reference, my lord, the office report.
Just a moment. I'm missing it somewhere.
Yes.
Well, this is the reference number only. So that
That is not the reference.
we have mentioned. Was it is claimed to have been registered on 25/8/2023.
No, my lord.
Just check-
25, my lord, that is not.
No, just one. You check on the Supreme Court website about date of reference number 1 of 2023. Go to Supreme Court website and find it out. No, apparently you are not right. First of it, comma, which appears to be not incorrect, as the contents of the office report of reference number 1 of 2023 of the Supreme Court of India refers to issuance of notice made returnable on 21
Reference 1 of
7
2023.
2023. Stop. Next paragraph. However, the petitioner was suspended. Page 29 is the order.
Yes.
The petitioner was suspended by
Deadline.
memorandum dated 15/6/2023 issued by the Secretary to the Government of Arunachal Pradesh, Department of Administrative Reforms. Postal. The comma, which is under challenge in this writ petition filed under Article 226 of the Constitution of India. Next paragraph. The case of the petitioner as submitted by the learned counsel for the petitioner is that only after the reference is registered before the Supreme Court of India, only then can the suspension of a member of the APPSC could have been ordered under section under Article 317 within bracket 1 of the sorry 317 within bracket 2 of the Constitution of India. First stop. Next paragraph. Per contra, the learned Additional Advocate General has submitted that the event suspension order was that the presidential reference was made on 18/4/2023, and the impugned suspension order was passed thereafter on 15/6/2023, which is stated to be permissible under Article 317 of the Constitution of India, as there is no express bar in exercise of power under Article 317 within bracket 2 of the Constitution of India. Subject to registration of the reference by the Supreme Court of India. Next paragraph. The provision of Article 317 of the Constitution of India is quoted below. Next paragraph. Next, on a reading of the provisions of Article 317 of the Constitution of India, the court is unable to hold that there is any provision contained therein which prohibits the competent authority to suspend the petitioner prior to registration of the reference by the Supreme Court of India. Next, madam.
Once the reference is made by the president, that is enough. Article
Next, madam. The learned counsel
317.
for the petitioner has referred to the Gazette of India notification dated 27/5/2014, published in the Gazette on 29/5/2014, regarding reference made by the President under Article 317 within bracket 1 of the Constitution of India. On a perusal of the rules framed thereunder, the court does not find that there is any prohibition for suspension of the petitioner till registration of the presidential reference made under Article 317 within bracket 1 of the Constitution of India. Next paragraph. In the considered opinion of the court, once a reference has been made by the President of India on, what is the date again?
18/4.
18/4/2024, the competent authority would derive power to place the petitioner under suspension. Stop. Next, accordingly, in view of the opinion expressed, this petition stands dismissed.
Well, otherwise, the reference is pending in the Supreme Court now. This reference is going on.
Yes. We don't comment there.
Obliged, madam.
Like,
I'll just take a 2-minute break and come back.
Behalf of the petitioner. Lordship, I seek one week time to file affidavit in reply against the affidavit filed by the state respondent.
I have serious objection.
Yes.
On 19/2/2024, we have filed our affidavit. It is now 3 months now. Since they are enjoying the interim, they are running away from the proceeding. They are enjoying interim, we fear the scheme might lapse.
Okay.
And
So file it within Friday this.
Lordship, I'm seeking only 7 days time.
No, we have already taken time. We have given you time earlier.
Lordship, our affidavit is ready, but the deponent is out of station. That's why it could not be swear.
We have given you time on 4/4. And 24/4.
With regard to the
6/5. No, let him come. Friday?
Yes.
Friday. Yes.
Lordship, 7 days may be given.
No, we are refusing it. Mr. T. Tabar, the counsel for the petitioner, prays for further 7 days time to file affidavit in reply in the matter. Next, the prayer for adjournment is objected to by Mr. B. Picha, learned standing counsel for the Rural Development Department, on the ground that the petitioner was already granted sufficient time by order dated 4/4/2024, 24/4/2024, and 6/5/2024 to file affidavit in reply in the matter. Yes, sir. Next, having
noted that there's a interim order dated 5/2/2024, restraining the respondent authorities to finalize the tender, the prayer for a long, prayer for adjournment for a week is refused. Full stop. List on next Fridays, 24/5/2024. If affidavit reply is not filed by then, the interim order shall be reconsidered on the next date of listing. List on 24/5/2024.
Lordship,
Same.
same.
Okay, interim order part
Same
list has extended. This 9 also same.
Same order.
Okay.
Deeply obliged.
But the writ petition was filed, my lord, challenging the decision of the tender committee, whereby, my lord, my tender was rejected and the recommendation was made in favor of respondent number 7. The grounds, my lord, taken among others that the respondent number 7 has submitted certain false documents. Apart from the other, my lord, grounds taken therein. Initially, though, there is an interim order, but that was vacated on 29/1/2024. And thereafter, I have preferred a review petition, writ appeal that was withdrawn, and thereafter a review petition was filed. The review petition came to be dismissed. Then again, a writ appeal has been filed. That order of writ appeal, your lordship will find at page 43, relevant portion, page 49. Lordship may come up, my lord. Page 49 of the IM. My lord. Paragraph 12. That gives the entire facts.
Page 44, division bench order 18/3/2024.
Lordship.
Yes.
It starts from
Seen that.
43. Lordship may come to page 49.
Yes.
Paragraph 12. Insofar as the plea of fraud or misrepresentation and or use of fake documents raised by the appellant's counsel by referring to form A submitted by the respondent number 7 and mismatch of figure in the certificate prepared by his certified accountant as concerned, we find that such plea has been substantially raised by the writ petitioner in the writ petition in paragraph 83. However, the learned single judge has not dealt with the same in the impugn order. Be that as it may, the said aspect of the matter would have to gone into and decide by the learned single judge in the pending writ petition at this stage of hearing of the petition, which stage yet to arrive. Here, informed that although the departmental authority have filed their counter affidavit in the writ petition, the respondent number 7 yet to file counter affidavit in the writ petition. Unless the pleadings are complete and the writ petitioner is taken up for hearing on merit, the allegation regarding use of fake documents and or preparation of fraud by the respondent number 7 cannot be determined by court. It is no doubt correct that the third allegation raised by the appellant alleging use of fake documents by the respondent is a serious nature, and if found to be correct, may entail serious adverse consequence upon the said respondent. However, it is to be borne in mind that unless a proper finding of fact is recorded by the court establishing the aforesaid plea, no order can be passed by this court merely on assumption of fraud. In order to avoid any prejudice being caused to the other side, we refrain from making any further comments in the matter at this stage. We are also conscious of the provision contained in 14(1)H of the Specific Relief Act 1963, restricting injunction order staying infrastructure project, and also recent decision of the Honorable Supreme Court in the MB Project Limited so, wherein it has been held that construction of road being an infrastructure project and keeping in mind the legislative intent being section 41H of the Specific Relief Act 1963 to the effect infrastructure project should not be stayed, the court to refrain from staying infrastructure project. For the reasons stated here, we are not inclined to interfere with the orders impugned in the writ appeal. We therefore dispose of the writ appeal with a request to the learned single judge to hear the writ petition on merit and pass final order therein by taking note of all pleas raised by the contesting parties as expeditiously as possible. in order to ensure that the interest of appellant is protected till such time the writ petition is finally disposed of. And keeping in mind to the public interest as large, balancing the equities, we direct the authorities not to release payment in favor of the respondent number 7 beyond the ceiling of 70% of total estimated cost of the work, subject however to fulfillment of other criteria by the contractor. The respondent number 7 would be at liberty to approach the letter single just so and so. The writ petition is disposed of with the direction that with the observation that the writ petition is disposed of as early as possible. Against this order, we have also approached the Apex Court. At page 52.
We've seen that the court has directed 22-4, you hear the matter. You've seen that the Supreme Court has directed 22-4, the matter will be listed. The single judge is asked to hear the matter.
So Supreme Court also said, we request the single judge to take up the petition with all reasonable dispatch. Now, bringing all this subsequent event, I have filed the instant IA to take it on for placing the materials on record, whatever subsequent development that has been taken place, my lord. And alternatively, my lord, if the objection comes for amendment, now they have filed an objection to that. So far as objection is with regard to the amendment, but they have not objected to the placing of the materials on record, my lord. So therefore, this my prayer would be, my lord, the IA may be allowed, my lord, these documents or the statement, whatever I may be, that may be kept on record to be taken up at the time of hearing. And
we will hear it. Supreme Court says you hear it, we are hearing it. Whatever documents are there, we will hear it.
Today itself?
Yes.
But they are yet
you see, you went to Supreme Court, got a direction, and we are here. Supreme Court says 22-4. If you want to get it modified, you'll have to do it in the Supreme Court. Otherwise, they will say that we are not working.
My prayer is that this
we will take it on record. Once it is there,
yes,
we'll
this
take it
is on record and date may be fixed for hearing of
no dates. Today is the date of our hearing.
All right, in that case.
Lordship, here by this filing this IA lawsuit, the petition asking for the amendment of the writ petition itself, lordship.
You see,
here by filing this IA, some new documents have been brought in, lordship, and I think we need to file some reply on this, lordship.
You see, the Supreme Court has issued a direction that with all reasonable dispatch you hear it.
Yes.
So therefore, whatever is there, you make your submission on the basis of materials on record. The only allegation is that the documents, 2 or 3 documents, which they say is false. Against that, the respondent 7 has given a reply.
This will not the part of the writ petition.
So that's okay. So we'll concentrate on whatever material is there. Because you see, we can't say to. You see, once the Supreme Court has given a direction of 22-4, 22-4 has today is how much?
Today is
20th of May. We have already violated the orders of the Supreme Court.
So, here, lordship,
no, so far
if these documents are to be relied, lordship, it has to be, lordship, taken into consideration without hearing us, lordship, without giving us opportunity to reply on that, lordship.
But it can't be done. You see, the response, the Supreme Court direction.
So far as the objection raised by the government advocate, my lord, lordship may kindly see the order dated 10/5/2024. They said they don't have any objection.
No,
it is only the respondent 7 who wanted to.
No objection as to the amendment, lordship.
Mr. Sekia, there are 2 things. Number 1, somebody is not objecting for an amendment. So if amendment is allowed, it becomes incorporated in the writ petition. Therefore, right to reply is always there.
Yeah.
You can't say that just because you did not make an objection, now you can't even file a formal objection.
No, not to the IA, my lord. I am saying I am submitting on the IA, my lord. In the writ petition, they are yet to file the affidavit in opposition by the private respondent, and my lord, the respondent number, government respondent, my lord, they have already filed affidavit.
It is there. Is Supreme Court has given a direction. You hear it, you start hearing.
In that case, lordship may take up.
Because you will have to go to Supreme Court and say that we were not given an opportunity of hearing.
It was not the case of that no opportunity was hearing. My lord, the lordship has seen the division bench observation that the fraudulent is a serious matter.
We are only on the one line order of the Supreme Court that the court will hear it at the what is the word used?
Reasonable
dispatch.
Yes.
So we start hearing it. we will take care of what is the nature of amendment sought for, why it is required, why it is not required. Those will.
I'm not going for amendment, my lord. I'm just placing it on record. They may have, my lord, this objection to the amendment itself is, my lord, delay tactic. The first, my lord, they have taken, my lord, the 10 days time to file the affidavit. None have filed. Then again, another week time has been taken to file. The government says, my lord, they don't have any objection. Now today comes up and says, my lord, they have objection. Placing on record, my lord, is not, my lord, otherwise also they cannot, my lord, object, my lord. But then, my lord, alternatively, I have, my lord, submitted that if they object to the placing on record, then the prayer for amendment may be considered. Now, they having not objected to the amendment, to the, my lord, placing on record. So these documents or the statement, whatever, my lord, that will be, my lord, brought on record and they'll file an affidavit. Now, if your lordship inclines to take up the, my lord, matter as per the Supreme Court's, my lord, that can be taken up, my lord.
You see, I have a very simple way of dealing with it. Number one, unless you permit us to mention in the order sheet that the adjournment is consented adjournment. You see, I'll tell you the way in which I wanted to proceed. Unless we record the consent of all the council here to have an adjournment. Number one, I am not granting an adjournment. Number two, the way in which I would proceed is to just record that the Supreme Court has issued a direction to hear the matter on 22/4. Now, to overcome that, an interlocutory application has been filed, and now the pleadings are being exchanged, and therefore new facts are to be brought into this. Since leave is not granted by the Supreme Court of India to allow amendment or to introduce new facts, we are hearing the matter on the facts available in the writ petition alone. So we allow your IA. But we hear you on the when you are delivering the judgment, we are basing it on the writ petition. So that's why I'm proceeding to hear you. I've given you my intention very clear. Supreme Court did not say that you file an amendment application. So we'll deal it with accordingly. Otherwise, if you consent at the bar, you record your consent and then we adjourn it. Because I am not going to take a adverse comments from the Supreme Court of India.
My lord, this IA has been filed, whatever I have submitted with regard to, my lord, going to lodgement.
I expressed to you my mind. I am doing so because I want to be transparent. I could have done otherwise also. I am not required to give an explanation, but I am giving an option. If the consent of all are recorded, then I adjourn the matter. But if anyone objects to the hearing, then we take up the hearing, irrespective of whatever facts you bring. I have a way to go out of that. I will depend only on the writ petition and will not cause an order. Because Supreme Court, you should have taken leave from the Supreme Court of India to make additional pleadings. So therefore, when you got an order from the Supreme Court of India, the Supreme Court issues a direction to the single judge to hear it, is on the basis of the facts available.
Yes, yes. Yes, it can be
So it's
hard
your
in that
choice.
case.
You can sit and discuss. If you want your concession to be recorded, then only I adjourn it. Otherwise, I don't. Please speak to.
No, my lord, this IA has been filed to place this material, certain material.
I told you, I have my way.
My lord, lordship will either allow or dismiss. That is another aspect, my lord. That this IA, my lord, for today, my lord. They have filed the objections.
I have expressed my opinion, although I am not required to. So please have a discussion with all four of you. If you arrive at a concession, that is okay. Otherwise, I start here. Because somebody makes brings out to the Supreme Court of India that we are not hearing the matter, there comes a stricture.
It is not that, my lord.
I have told you, Mr.
In the writ appeal, my lord, for
Mr. Saikia,
with a renewal of
I have-
prayer of,
I have-
my lord, stay.
I have read few orders and I'm very clear about going to come. I have a duty to express myself to you, but I am doing so because I want to be transparent. It may sound harsh to you, but that is the hard reality. I am not bringing a stricture against the court just because for an adjournment, unless there is a consent at the bar.
But this apex court did not put it as an
You
stricture.
should have foreseen it. You should have asked the Supreme Court that we want to exchange pleadings. Once the Supreme Court direction is there, you can't say that under 142 I am not bound by it.
It just simply said, my lord, at a reasonable dispatch, my lord. That much said, my lord.
Reasonable dispatch.
And this is, my lord, bringing on record.
Mr. Saikia, I have told you. I reserve my comments now. I am not expressing any further. I implore upon you to start hearing the argument in the petition. Otherwise, if they consent, yes, you consent to the adjournment.
No,
Huh?
no. Yes, here also issue is whether this IA is to
No,
be-
adjournment is yes or no?
Yes,
Yes, Mr. Sharma.
from my side, no.
Actually, the today case is fixed for hearing of the IA.
No, not hearing of the IA. You did the Supreme Court order. Supreme Court
yes.
doesn't say IA.
Now, if your lordship want to hear the and then matter, I am ready.
You?
I put
Oh, you are assisting to him. Okay. Then we proceed with the hearing.
My lord, on 16/10/2023, RFP was issued, my lord, at page 29. It is for
Yes.
Page 31 is the, my lord, total estimated cost is 3174, my lord, and stipulated period of completion is 30 months. Now, the eligibility criteria, which will come to my lord, page 33. The Executive Engineer, Naharlagun Division, PWD AP, Naharlagun, on behalf of the Governor of Arunachal Pradesh, requests online submission of RFP showing expression of interest, technical bid from eligible bidders, meeting qualifying criteria prescribed as para 1.7 for construction of road project in the state of Arunachal mentioned as under.
What is the date of this?
My lord?
What is the date of this?
Date.
Of the NIT, this RFP?
RFP is 16/10/23.
13/10?
16/10/23.
16/10/23.
It is appearing at page 29.
Yes.
Now the one has to qualify as per the para 1.7. Now this para 1.7 is at page 34. Bidders should be either enlisted with any of the enlistment authority and shall be governed in accordance with the provision as per Arunachal Pradesh district-based entrepreneur professional enterprise. So and so, so and so. Then Lordship may skip the address, my lord.
17.1, 1.7.1.
These are requirement, my lord, this 1.7, my lord. Lordship may skip all, my lord. Lordship may come to 1.7.2, my lord, and 1.7.4. These are the two relevant, my lord, clauses. 1.7.2, similar nature of works. The bidder should have satisfactorily completed the one work as mentioned below during last 7 years, ending previous date of last date of submission of tender. my lord, one work that has been executed during the last 7 years. Provided that at least one similar work of 20% on estimated cost put to tender of rupees, so that is not less than 63.40 crores should have been completed. That, my lord, out of these, my lord, the 7 years, my lord, works, one has to be minimum, my lord, 20%. That is the eligibility criteria.
Yes.
Then clause 4, completion certificate with correspondent address, email ID, contact number, issuing authority in the rank of executive engineer or equivalent must be uploaded with participating in the tender. That particular work, my lord, which has been executed of 20% and more, my lord, that has to be certified by the executive engineer. Then 1.7.4, financial soundness. The bidders should have average annual financial turnover of not less than rupees 158.50 crore on any works contract during the last available 5 years balance sheet duly audited by the chartered accounts. So this was raised. My tender was rejected, saying that I do not fulfill this criteria.
17.4.2.
1.7.4.
Huh.
1.7.4, I do not fulfill this criteria. And taking this, my lord, ground, my lord, rejection of this ground and allowing him, my lord, I have challenged the, my lord, petition. This court by an interim, my lord, while my lord, considering the interim prayer, it has come to an opinion that this has to be average of 5 years. Our contention was that in 5 years, in any 1 year, if someone executes more than 158.50 crore, in that case, this would fulfill the criteria. The court has said, that no, this has to be average of 5 years. That was taken in the appeal, which was I have just pointed out to your lordship with regard to the writ appeal. There also the division bench has, my lord, favored the honorable single judge's observation that this criteria has to be of the average of the 5 years, not for an individual year. If someone does more than 158.50 CR in a particular year, and if he doesn't do the works in the other year, that will not do. So therefore, that has been, so far as this argument is concerned, so that is, we have to accept, my lord, that it has to be average of 5 years. Because division bench also prima facie said, and the honorable single judge also. So what my submission is that will be.
But I have a different theory. While determining the interim order, if any observation is made, there is not a final conclusion for the purpose of a final hearing.
That is true. That is true. That is true.
That is only for the purpose of considering the prayer for interim relief. Prima facie case not found.
Yes.
Doesn't mean that the writ petition has no merit.
That's true. That is there. That is the, but even, my lord, assuming that this is an average, I would like to proceed in that way. Before that, may I submit one thing? There may be some urgent matters also if they continue complete their works and then we proceed the matter.
No, we'll see if others can be adjusted.
So this is the 1.7.2, my lord. This is the 1.7.2, my lord. Two things are there, my lord. That during the last 7 years, one has to complete one work of the similar nature. And out of this work, one has to be minimum 20% of the estimated cost of 317, that is 63.40 crores.
Plus 90% work should have been completed.
My lord?
Plus 90% of the work should have been completed to constitute 20%.
Yes, yes. Yes, even if the work is not completed, then also it, if it is 63.40, that will do, my lord. Now, so far as, my lord, the evaluation criteria is concerned, your lordship will find, my lord, Schedule C is the, my lord, documents to be uploaded at page 49.
49.
49. What documents are to be uploaded, my lord? Schedule C. Clause 1, your lordship will find the receipt of bid processing fee of rupees 25,000 issued by Naharlagun PWD division, and the format has been given at page 60.
Yes.
Page 60, this is the format. That means, my lord, the bid processing fees after depositing, this receipt will be given by the authority that is to be submitted. Why I am referring, my lord, one of the tenderer who was, my lord, Aridius respondent number 9 in the writ petition, but subsequently his name has been its name has been deleted. That tenderer has submitted the bank draft, not the receipt. That is at page 179. At page 179.
179.
This is the bank draft, not the receipt as has been provided by the format, my lord. Page 60.
Yes.
That's right. Then, my lord, will find clause 7, affidavit executed before judicial magistrate indicating that furnished statements are true and will abide by the terms and condition of RFP. That affidavit is given, my lord. Then certificate of work experience issued by the competent authority, not below the rank of executive engineer and equivalent. This is in conformity to the clause 1.7.24 that I have taken to your lordship, my lord.
Yes.
And then next clause, certificate of annual financial turnover with profit loss details for the last 5 years from chartered accountant in form A. I'll take your lordship to the various, but before that, this very.
Mr. Saikia,
Lordship.
you see, I'm just juxtaposing your submission along with the affidavit filed by the state. You refer to the receipt of the amount against which a bank draft was issued. Their response is that before that opening, it was already credited to that account. That is their affidavit at page. In their affidavit opposition, they say that. So therefore, this.
But my endeavor would be to show that fulfilling these criteria are not, doesn't give a right to the tendering committee to reject the tender, because the tender evaluation, my lord, will be as per my lord, Schedule D.
Schedule D.
Schedule D. At page 61. mandatory document, if someone does not upload, he may be rejected. But non-fulfilling of this particular criteria of 158.5 CR is not the one, my lord. Let's come to page 61.
Yes, I'm there. I'm there.
This Schedule D technical bid evaluation process. Bid opening committee during the opening of technical bid shall verify the following documents uploaded during bid submission, original or downloaded copy as a prerequisite for carrying out further evaluation of technical responsiveness of the bidders. First, my lord, they'll see, my lord, the prerequisites: proof of payment of bid fee of rupees 25,000. So receipt has to be there to further proceed. But in this case, I have shown, my lord, he has submitted along only the bank draft, not the receipt. The technical committee still have evaluated the bid of the respondent number 9.
Okay. Yes.
Now, if you also comes to clause 6.2, in addition to fulfillment requirements laid down at Schedule C, technical evaluation of bidders shall be determined based on the minimum score shown below. So, my lord, it makes it clear that the documents, whatever mentioned in Schedule C, have to be uploaded. And then, my lord, the score will be as per, my lord, given here, my lord. Now, this particular clause with regard to experience in similar nature of work. That is clause, my lord. One point 7.2.
Which page?
My lord, the number one, my lord, experience in similar nature of, this is in consonance with, my lord, 1.7.2.
No, 1.7.2 is page number?
Experience, my lord.
Page 35.
Page 30 is the 1.7.2.
Yes.
Here, maximum marks is 20 and minimum qualifying marks is 10. They have set in this year seen 63.40 crores.
No, this marks 10, where you are getting it?
My lord.
10
Page
marks, where you are
61.
getting it?
Page 61, my lord.
61. Yes. Yes.
This is mark is 20 and minimum qualifying marks is 10. So, and let's say we'll find the target is 63.40 crores. So my submission is that if anyone's fulfills this criteria 63.40, in that case, he'll be given 20 marks. And if he is lesser that way, it will come down to 10. And those who qualify less than the 50% of 63.5 crore, in that case, he'll be failed. He'll be out of the sin menu.
Yes.
Now, so far as financial soundness is concerned, my lord, that is form number A, my lord, serial number 2. So this financial strength will be evaluated on the basis of form A and form B. My lord, various forms are given, my lord. Page 52 is the forms. This is gross annual turnover.
Yes.
Form number A, you'll also page 52, financial detail to be funds duly supported by figures in balance sheet profit and loss account for the last 5 financial years duly certified by the chartered accountant as submitted by the applicant to the income tax department, copies to be attached. My lord, we are not concerned with this B, my lord, for time being, my lord. This form is relevant. Then relevant, it be the form C at page 53. This form C at page 53.
Yes.
It has given, my lord, 10 columns, my lord, different parameters to be mentioned. This is with 1.7.2. For last 7 years, one has to give this. Out of the 5 years, average will be taken up. And then clause 1.7.4 and 1.7.2 would be evaluated. This is form C.
Yeah.
Other forms are there, will come to the later part, my lord. Now, coming back to the, my lord, page 61. My lord, this financial strength, form A and B, then performance of work, that is form C. Last 7 years, what he has done, that is the form C. And then performance work, form C, quality. Out of this, my lord, 40 marks have been awarded. Total 60 marks have been awarded. 80 marks have been awarded. Performance 40, performance of work, form C 20, and financial strength is 20. So if someone gets 40, he qualifies. So therefore, my submission is that if someone achieved the 158.58 crores, in that case, he gets the full mark 20. So far as clause 1, first work is concerned.
Yes.
Now, so far as my average of 5 years, it comes to it comes to something about 114 or so, my lord. 121 is the form A submitted by us. 121.
121 crore.
Page. No, my lord, at page 121. This I had calculated what would be the average of the 5 years. My lord, it comes to something. In that figure, I'll be my lord, giving a lordship. It comes to something about my lord, 120 crores average for the 5 years. Less than 158.50.
It will be less than 1.21 crore.
My lord?
It will be less than 1.21 crore.
Yes, my lord.
Average, on an average is 59 crore. 59 crore divided by 5 would be
No, my lord,
1 crore.
there's one more calculation.
1.3.
There's one more calculation. Year-wise, my lord, some addition comes. My lord. If the work is of 2019-20, then he gets addition of 1.5%. This calculation is also there. So that's how, my lord, I'll be giving you a lordship, but it is less than 158.5 CR as required.
Okay.
This is my form. My lord. So therefore, my lord, as per this, it comes to, my lord, 120.41 CR. Yes.
Has to be.
And as per the calculation that is further given for addition of percentage, that comes to 136.09 CR.
126 crore.
136.09 CR. After giving the addition as per the calculation to be made.
Yes.
Now, as per the Schedule D, my lord, I have submitted all the documents. There is no denial of that, my lord. Only thing is that I do not fulfill 1.7.4 that my 5 years average turnover is less than 158.4. Now, from this calculation, your lordship will find the financial strength is 20. Then performance of work, 20. Page 61.
Yes.
Combination of form A, B, C. Different parameters are given, total 80 marks. If someone gets 40, he qualifies.
$60.
Total 50 marks. No, from this second, my lord, first is number one is, my lord, experience in similar nature, that is 1.7.2.
You're reading where? Which page?
61.
61.
61. This Schedule D technical bid evaluation process.
Yes.
Experience in similar nature of work, 20 marks. Out of that, 10 marks. This is with regard to
60 is the qualifying marks. Total last is 60.
Last is 60. For the part one is 50. And then later part technical tools and all these things, 10 marks is there.
10 marks is there.
So total out of 120 marks, if one secures 60 marks. So, and none of the other clauses says if someone does not fulfill any of the criteria, his tender is liable to be rejected. The tender condition does not have that clause at all.
Does not have a clause that
Non-fulfillment of any of the condition eligibility criteria as such.
yes.
If someone do not upload the documents, in that case, his technical bid will not be open. That is the mandate of this Schedule C. Technical bid will be open only if all the documents are uploaded and receipt of the bid amount. Now, one more clause, Madam, page 38. That is information to bidder. Clause 8. Bid uploaded with fake or false documents, if established during evaluation scrutiny, is liable to be rejected without any intimation and cannot be challenged. Page 38.
Yes.
Because my whole allegation is that he has submitted false document, that he has committed forgery. So he is at any time is liable to be rejected. So far as my ground is concerned, page 26, your lordship will find
Yes, 38, which clause you said?
page 38, clause 8. It starts from 37,
Oh,
clause
okay, yes,
2.6.8.
Yes, yes.
2.6 Roman 8.
Yes, yes.
Actually. No. The evaluation committee report, your lordship may kindly see, my lord. Page 26, my lord. Page 26, these are the 4 responsive bidders. And private respondent number 7 is at serial number 4, Kenge, who has been awarded the contract later on. And others were added as respondent number 8, 9, 10. And so far as the rejected bidders comments are at page 27, I am at serial number 1. Page 27.
Yes.
Messrs. Navam Tolon LLP. Turnover below minimum qualifying criteria. That is the criteria for which I have been declared as non-responsive. In the middle, you also will find non-responsive. And so far as respondent number 7 is concerned, his at serial number 13, eligible and qualified, substantially responsive. Then TK Engineering, substantially responsive. Then respondent number 9, Ganon Dunkardle, substantially responsive. So these 4 names are there at page 26. And my criteria is that I do not fulfill the criteria 1.7.4.
Yes, that's it.
Now, Lordship may kindly come to Lordship in page 35. These are the similar nature of works. I have already point 1.7.2 adjournment I have said, my lord. Now, his form A and form C. One three zero. This is form C of that's one number 7. Now this form C the form C prescription is at page 53. I have taken your lordship. That contains 10 column. The last column at page 53.
Page 53.
Page 53. Form C of respondent number. This is the specimen, page 53. It contains 10 columns. But this form, it doesn't have 10 column here, only 9. The last very important is whether the work was done on back-to-back basis, yes, no. Because subcontractor would not be perhaps entitled as per the 1.7. He has to work of his own, my lord, during the last 5 years.
We'll continue tomorrow. We'll pass on our orders in other matters. We'll take it up tomorrow. The submissions of Mr. PJ Saikel and senior counsel.
My lord, the lordship is sitting for 26. Let it be fixed on next month.
No. That's why we asked for consent. If consent is not the way to take up hearing. We are not inviting Supreme Court strictures like that. Assisted by Mr. Counsel with the petitioner. Mr. A.C. Sharma, and senior counsel. Assisted by Mr. B. Halder, the private respondent number 7. Mr. S. Tapil, and additional, senior committee preparing for the state respondents. And Mr. T. Taba, counsel for respondent number.
No, he is with
Oh, with you. Okay. Present.
My lord, your lordship will not consider this
No, you make your submissions. What I'll do is unpredictable. You be prepared to argue on this also. I'm not saying anything more. The submissions.
No, where,
It represents. Remains inconclusive question, huh? List for hearing on.
actually in the main lead petition,
No, we don't know. I expressed my mind earlier. I'm not repeating it again.
And the records of read appeal number 8 of 2024 may also be, my lord,
Which one?
read appeal number 8 of 2024. They are,
Recommend us yesterday, tomorrow we'll call it.
because they have filed respective affidavit in the read appeal also.
It's okay. Just when we yesterday, tomorrow we'll call it. It's not the registry will not be, there will not be no persons there to get it.
if it is next Monday, because I had some fixed method.
No, I understand, but you can't help it. You asked Mr. Halder to be here. That's why you said, I expressed my mind earlier. Without consent, I'm not adjourning.
And in that case, your lordship will not consider this.
Make your submissions. What I'll do is a different matter altogether. I've expressed my mind. I'm not repeating it again. You make your submission on merit.
What take up on
In whatever
27?
manner you want.
Which may take up on 27, my lord, if he is facing any difficulty.
I have difficulties, I know. You see, we get. I may not say anything. Please try to understand when I'm saying so, I do it with all respect. We have had all our bad share of bad experiences. Yes. Next matter. Okay. Mr. Dolo, your matter.
I'm appearing for respondent number 7, my lord.
Respondent number 9, no, you are for 9.
7, my lord.
7, 9 is
7.
not yet served.
No, the notice have not gone, yes. 8, 9 notice have not gone. So
Not gone.
not gone. Yeah, let the notice go, my lord. Lordship, stay has taken lordship. Petition of 4 and 5, my lord. 4, 5.
You're for 7.
I am for 7. And in fact, I am from the same Union of India, my lord. This is the employee of the Union of India. 4 and 5. Notice have not gone. Notice is not issued.
On 8, notice is not even issued.
Yes, my lord.
Okay. Mr.
Lordship, last day lordship, fresh notice for respondent number 9 lordship, it has taken lordship. So matter may be fixed for net date lordship.
Your name?
Honi Tana Tara lordship.
Honi Tana
Tara.
Tara, counsel for the petitioner. And Mr. Y. Dolo, then counsel for respondent number 7. Next matter. It is observed that no order has been passed for issuance of notice on respondent number 8. To stop accordingly, the petitioner shall take steps for service of notice on respondent number 8 by registered post with AD. To stop. Notice is made returnable on. Give a fixed date after 4 weeks. Date. Give a date after 4 weeks. 17? 17 June. Okay, 17/6/2024. Next one. In the meanwhile, list the matter before the Ravasima Court for passing appropriate orders as regards service of notice on respond number 9. And who's for others?
Well, the notice have not gone to the 4 and 5. That will enable us to file the affidavit in opposition because
4 and 5 also notice not issued.
no, not issued by the.
Just a moment, then. For notice is not also issued in the other on others.
Yes, my lord.
Oh. Yes, say, along with 8, you also say notice has not been issued on respondent numbers 1 to 6. Same order, huh? 1 to 6 and 8. Oh, no. This court has issued only orders on 7 and 9, on no others.
Yes, my lord.
So there must be some reason the court did not issue notice on any other respondents. Why? There is a specific order.
Last time I did not appear, my lord. My learned
No,
counsel.
this only the order is since the petitioner is furnished copied only to respondent number 7 and 9. Let notice be issued to the respondent number 7 and 9 only at this stage. Eternal in 4 weeks. So therefore, notice is not issued on others. Yes, what is the submission?
Lordship, maybe allow for the fresh notice issue.
No, question of fresh notice is not there. The notice order for issuance of notice on the respondent numbers 1 to 6 and 8 was not passed earlier. Can you tell us why? Oh, we now get it. The lecture 5 series. We got it. Why the reasons? The notice will not go to any others. Notice of the order of the court was only to Deputy Commissioner and Commanding Officer.
Yes. Then this matter let it come on 38, 30, because then that they will conduct the hearing. 30, 38.
Next paragraph.
May.
Don't write that, huh? So petitioner and respondent number 7 is present. The service on respondent number 9 is awaited. So accordingly, list the matter before the Ravasima Court for passing appropriate orders as regards service of notice on respondent number 9. Next paragraph. Thereafter, list the matter on 305/2020.
Yes.
4. Just add this somewhere. It may be mentioned that by order dated 24/8/2023, reasons have been assigned only for issuance of notice on respondent numbers 7 and 9.
Yes.
This is the first line, huh? Okay.
Oh, let's
30. It lost.
May I fill in, my lord?
Yes.
Here, the respondent number 1, 2, 3 has filed their affidavit, and 4 and 5 is yet to file.
Yes. They are giving a walkover. They don't want to file.
Lordship, I need some time. I'm for respondent number 5 to
Okay, you
file
want some
affidavit.
time. Okay. Mr. N. Taji.
Yes, madam.
Learned counsel for the petitioner. Ms. R. Basar Leonard. Government advocate, appearing for respondent number 5, place
Yes.
for adjournment. Who's for 1, 2, and 1 to 4?
I am for 1, 2, and 3, Your Lordship.
1, 2, and 3, you are there.
Yeah, we have filed our affidavit.
Okay, 1, 2, and 3, your name?
T. Marngar.
T.
Marngar. Marngar.
Magar Leonard. You are CGC?
Your Lordship, for Power Grid.
Acha. Okay, Learned counsel for respondent number 1, 2, and 3 is present. This power department, no one is there.
One L Permay there
Standing
for
counsel.
power department. He is absent today.
Okay, now appears on call for the respondent number 4. Next para, the learned government advocate for respondent number 5, praise for is granted. How much time? 3 weeks time to file affidavit in opposition in the matter. Just after 3 weeks.
Your Lordship, if we can be on the 7 of June.
Well, let them file an affidavit. After that, we'll fix a date for hearing. You are from here only?
No, I'm from outstation, Your Lordship. That's why I pray for accommodation of the date.
Okay, 7/6. Just a moment.
All right.
7/6, okay.
I please your lordship. This is the IA, your honor, your lordship. Praying for the modification and the correction of the order dated 02/03/2022. May I please your lordship, page number 9 in my petition.
Yes.
Only the direction may be passed me, your honor, to file a fresh petition regarding the earlier disposal of this writ petition, your honor. That must be my prayer, your honor. No more prayer is there, your honor.
Where's the writ petition, connected writ petition? No, this order was purposely fast.
Yes, my lord.
We did not grant you liberty, knowing what we are doing it. You can't be given a liberty. Because the disciplinary proceeding covers for the period when you have not received your salary. June 2015 to July 2017.
That's true, you know.
Correct.
Correct.
So what has happened to the disciplinary proceeding against you?
My
That has
lordship.
attained finality.
Yes, my lordship.
That has attained finality. Correct. In the disciplinary, that final order that was passed, what is the direction given?
Your lordship, as per the direction of my senior counsel, I say so, kya? I just highlighting the IA case, Your Honor. So regarding the main suit, the leading counsel proceed the same.
For the same relief, you approached what you call another high court.
Yes.
Your petition was dismissed there. Review was also dismissed. That's why we did not give you liberty. You withdrew it. Your liberty can't be given. Your petition was dismissed by on merit by the other high court. What is that high court? I forgot. High Court of Rajasthan. No, we are refusing it. We are refusing that leave. IA, this Mr.
M. Bagra. M. Bagra, Morik Bagra.
Bagra. Then counsel for the applicant, and Mr. M. Kato, and CEC appearing for the opposite parties. Next, para. This in This could by order dated 2/3/2022 passed in WBC 114 of 2018 permitted the petitioner to withdraw this writ petition as not placed. Accordingly, this by filing this interlocutory application, the petitioner is seeking leave of the liberty to file a fresh writ petition. Next para. It appears from the materials available on record that the petitioner has approached the Rajasthan High Court where is that Rajasthan High Court? You said somewhere that it is still pending. In your affidavit in opposition, please find out. What has happened to the inquiry? Disciplinary inquiry is what at what stage? What is the stage? Disciplinary inquiry is at what stage?
The officer may be issued compulsory retirement.
We are reading from where?
IA 32.
IA 32.
There are 5. During the pendency of the administrative regulations, he was forced to take compulsory retirement from the service on 14/6/2019. The age of 56 years. After his compulsory retirement, he instructed his counsel to renew his because the differences are yet to be ended.
We just say that this records available. The As per the stand taken in the affidavit in opposition, in paragraph 10 of the affidavit in opposition filed by respondent number 1, it appears that the petitioner, the applicant oblique petitioner, had continued to remain absent on duty till 18/5/2017. It is also projected that the petitioner had obeyed the orders to appear before the inquiring authority. And accordingly, a stand was taken to the effect that the salary for the period from 9/6/2015 to 22/5/2017 can be decided by the competent authority as per rules after finalization of the inquiry. Full stop. The status of the inquiry against the petitioner has not been brought on record. Full stop. However, in this interlocutory application, a stand has been taken that during the pendency of the writ petition, he was forced to take compulsory retirement from service on 14/6/2019. Full stop. Therefore, nonetheless, in this writ petition which was filed on Fourteenth, 2018, the petitioner had made had sought for relief of directing the respondent authorities to pay salary to the petitioner for 26 months from June 2015 to July 2017. Full stop. The petitioner having taken a compulsory retirement on 14/6/2019, cannot be permitted to re-agitate the prayer made in the connected writ petition claiming salary for June 2015 to July 2017. Next paragraph. However, if the petitioner has any other relief to be claimed, it is always open to him to ventilate his grievances in such manner as the petitioner is so advised. I disposed of. We are not giving that liberty for that period of salary. Other remedy you have, you may able that.
Is it better?
This is
My lord, in 17 and 18, my learned friends have been engaged. So they have not even gone through the brief. But my lord, in this case, my lord, we agree, both of us, that matter is required to be taken up for hearing. So my lord, for admission hearing, if it is possible.
Agree to a date, both of you.
30th, he is coming. He says 30th only, 30, which is Thursday. So I have no difficulty with that. And my lord, in the meantime, 2 interlocutory applications are there filed by us that have become infructuous. So if those 2 IAs can be closed, at least the burden will be reduced. So these 2 IAs are in Item number 18, my lord will find.
That is a good thing I had today.
So at least IA, my lord, because my brief also will be reduced. IA 130 of 2022, it has become infructuous. 214 of 2022.
And Mr. P.K. Tiwari, Learned Senior Counsel, assisted counsel for the applicants. Stop. Also heard Mr. S. Tapin, Learned Senior Government Advocate for respondent number. For the state respondents, for NHPC who is appearing.
NHPC, my lord, I am appearing. Writ petition is by NHPC only.
Okay, so this is
WPC 242 is by NHPC.
no, this IA 73 is by whom?
They have filed. They are asking for awarded amount.
So this is live or can be closed?
My lord, in 73, I have gone through their application. What they are seeking is awarded amount has to be paid to them or expeditious hearing. 73 by them. My lord, we have 85 of 2024, the last IA. Here we say either stay the award because they are asking for awarded amount or expeditious hearing. So expeditious hearing, both of us agree. So 73 and 85, my lord, may be left intact and other two IAs can be closed.
There is no other IA. There's no IA. Sure.
Because pressure is mounting on us also. They're asking for money. We don't want to pay, obviously, because writ petition is pending.
No, you're wrong. In fact, once you release money, the pressure will not be there. You see, I don't have blood pressure.
No, my lord, lots of communication by the state government also.
I don't know. I'm just sharing my experience.
No, that's true.
Without that vitamin M, I don't have blood pressure.
So, my lord, IA 130 and IA
130. Okay.
214.
So for the applicant, Mr. Estapin, there is Senior Government Advocate appearing with the state respondents, and Mr. D. Das, Learned Senior Counsel, assisted by Mr. Adi Fukan, Counsel for respondent numbers. Here you are in this IA. 13214 respondent numbers.
All right.
No, we are closing this two IAs. Of
130 and 214.
You are not parties there.
They are parties in all the IAs. Naturally, you are the.
No, I am not in that case. Your case. Not 73. You're closing I is something
Acha, that is.
Yes. We are not concerned.
Lord, they are parties very much in those IAs because they are the private respondents in my WPC. Since they are the private respondents in WPC 242, naturally, my lord, they would also be the private respondents.
No, Mr. Das doesn't know.
I don't know anything about
Oh, well, fine, but my lord,
my learned friend.
since my lord, I am closing my IA. Since I am closing my IA.
We record your presence and he's closing it.
No, he's closing about his IA because our IA is.
No,
all right, your IA I
he's
am not touching.
He's not touching your IA. Here you will be private respondent number.
Yes. IA 130 and IA 214.
Here respondent number, private respondent numbers.
Below that I will kindly bring.
What can be done? It can be closed on 38 weeks.
Oh, very well. I have no either way.
It can be closed.
Very
I
well.
also let me go through it. I fully believe it. It's not that. Let it be closed on 38 itself.
All right. No problems. Let it be that way.
In the connected repression, right? As agreed to by as agreed to by both sides.
That's all. I wanted to say no time.
List the matter on 30/5/2024.
My IA cannot be beneficial to you. My IA cannot benefit you.
These were private respondents. Okay.
Well, not very well. So 30th, not for admission hearing.
We are not saying that. It will come on the same column. We are not saying that. It will come in the admission column only.
What? Well, not this time it came for orders. So again, it may come for orders.
Admission column. Okay.
Lordship, IA 19 is for implement, Lordship. And IA 19 is for implement, Lordship. Lordship, this matter may be first of all for tomorrow, Lordship.
No, not tomorrow.
Petitioner, Lordship, file objection, Lordship. Objection for the
Not
impleement
tomorrow,
law.
day after tomorrow. No, one by one. This is item number 19
19 is for implement lordship.
for implement.
In the case of item number 20 lordship.
Okay. You want to do a day after tomorrow?
Yes, lordships. Read petition number 171 lordship.
No, you want to take it day after tomorrow?
No, lordship, tomorrow lordship.
Tomorrow, no, we are not fixing tomorrow.
Tomorrow lordship, this is tender matter lordship.
Interlocal matters, we are not taking up tomorrow. Day after tomorrow.
Day after tomorrow, lordship, may please.
Okay, both sides are represented. No, no. You are for applicant.
Lordship, I am for IA applicant, lordship. I am want to implead in petition 171, lordship.
Then why are you taking an adjournment?
Not lordship, but my friend on other sides is
No, he's not making a prayer for adjournment. We allow this IA. That's okay. This IA we allow.
No,
He wants to be impleaded.
lordship, exactly, lordship. Here, lordship, he's senior objecting, lordship, and he is now not in here, lordships. Respondent, lordship, senior counsel, and is not here, lordship. See, objecting, lordship, for implement, lordships. My implement, lordship.
He's objecting to
Yes,
it.
lordship. So this matter may fix for tomorrow, lordship. I pray, but if lordship is tomorrow, lordship. Day after tomorrow,
along
lordship.
with
No issue, lordship.
IA is the petitioner, Mr.
Jiba,
Jiba for the applicants. And Mr. Tony Titi Tara. Tana Tara, counsel for the lead petitioner. Are present as agreed to by both sides. List on day after tomorrow.
Day after tomorrow, lordship.
Interim order passed today stands extended till the next day.
Okay.
The item number 22, the government's affidavit is yet to come. But before that, my lord, there is an IA filed by the pro forma respondents. Pro forma respondent number 3.
23, I am there, my lord. Item 23 is also connected.
23.
23.
Item 23. Yes.
So I am appearing in item 22, my lord.
Yes.
Where, my lord, the government's response is awaited.
Awaited. In both the cases.
In both the case, my lord, the government's response is awaited, my lord. And item 20.
Item 22, Asray Foods.
Yes, I am representing the.
Here there is an IA.
Yes.
For modification of the order.
Yes. Yes.
We should notice you respond to it.
Yes.
Respond to it. How much time?
2 weeks may be granted, my lord.
Oh, acha.
So let this matter come on 30.
30.
They will take time, so they let them file objection.
Okay. This IA, right? By Mr. Dida, senior counsel, assisted by Mr. V. Picha, counsel for the applicant, as well as Mr. Asdatar, senior counsel, assisted by
Aidas.
Yes, Aidas, counsel for the opposite party number 1. Government is a party here.
Yes, government.
For
government.
Who is Ms. Basal and the government appears for respond number 1 and 2. Okay, your name? Ketal, the counsel for respond number 4. Next one. Issue notice on this application filed under Article 226 with the bracket 3 of the Constitution of India for modification of the interim order passed on 4/3/2024 in the connected writ petition. Full stop. Objection, if any, be filed
by the writ petitioner on 30/5/2024, post on list on 3/35/2024. In this connected writ petition, here Mr. Datta would be the petitioner. State is respondent numbers 1 and 2. 3 is by
One-
Mr. Glass.
120.
4 is by Mr. Talukdar. As agreed to by both sides, list the matter on 3/04/2025.
My lord, can it be first of June, my lord?
3/05.
Because, my lord, item 23, I am there, so can it be in the first week of June, my lord? I shall be out, my lord.
Okay, just a moment. No, that's okay. One by one.
Yes.
This
Any
is
date in the first week of June, my lord. Maybe fourth also.
93. Okay.
So item 22, your lordship is the writ petition, your lordship.
30.
Yes.
Ah.
Your lordship is fixing the writ petition on 30.
Same day.
30. So, my lord, there is an interim order passed that may
Okay,
be
interim order passed earlier. Stand extended till the next date of listing.
So,
pending objection in the connected IA.
So in the IA and the writ petition both will be listed on 30.
Same day.
Obliged.
Now, this is item 23, madam. 33.
23.
23, my lord. I pray, my lord, that in that matter also, my lord, I is there, and 2 affidavits are filed by 6 and 7. Government affidavit is awaited. So both the matters can be fixed, my lord, in the first week of June, my lord, 4th of June.
38 is the station.
No, I know, 38 is the date for the last, your lordship is fixed on
38, I
38.
shall be out, my lord, virtually.
He'll be out of station.
I shall be, my lord, out of India, my lord.
We'll VC, we can do VC also.
No, he's on
Out of India, my lord, actually.
He's
Out
out
of
of
India.
India.
Out of India,
So,
dear people.
10th of
Can we read on 4th of June, my lord?
No, 4th of
4th of June, ठीक है, 4th of June.
My lord, either 3rd or 10th.
Tuesday, no, third only.
10th of June.
Third, make it on 3rd. 10th is difficult.
No,
Third.
he'll not be here. He'll
No,
be out
he'll
of
be
India.
there on 4th, no? 3rd, no.
10th, my lord. 10th to
3rd,
this is 3 operate.
no, he is there on
It can
3rd
be,
June.
my
I
lord.
think.
6.
3rd is there, 3rd June.
3rd is there.
Third-
Okay. Here, this is civilized for the writ petitioner. Along with Mr. A.K. Saiwala, counsel for the petitioner. 1 and 2. 1, 2, and 3 is Ms. Basar.
I am looking for 7.
Just one by one. For respondent 1, 2, and 3. No, in this writ petition 115.
115.
115. There are only three respondents.
No, my lord.
Originally, three
There was an
respondents.
amendment.
Huh?
Amendment.
Subsequently,
Amendment is here.
No, amended repetition is not here. It's not here.
I already filed.
I don't know.
And 6 and 7 are affidavit also, my lord. That's one of 6 and 7.
We file affidavit also, amended also. Thereafter, we file.
WC
reply.
115. I
Yes.
don't know. There's
But
no-
prior to amendment, we were not a party in this case. After that, they made a party, then there was an amendment.
Neither the amendment order nor the amended repetition is here. Please check up. It's not here.
115. Oh. No, neither, I think, my lord.
This order was passed in interlocutory application. We have 73.
Yes.
But amended repetition is not has not come on board.
No, that's not.
Acha, then you say. Extra. You see, in terms of order dated 8/4/2024, passed in IA Civil 55 of 2024, comma, respondent numbers 4 to 7 were permitted to be included. Full stop. Next, accordingly, the learned government advocate also appears for respondent number 4. And for 5, 6, and 7, who are there?
We'll argue on 30.
Okay, 5 and 6?
6, 5, 6. Only 6.
Only 6.
I am for 7.
5. Mr. Datta is not there?
No, he is not.
no.
He is not accepting. That's the whole problem.
Oh, acha.
Neither he is the party. So my lord will make it clear on 38. I'll argue on the IA application. They will not take objection saying that it is together, so it should be heard because
that's why we are doing
NIT is saying.
No,
that,
that
yes.
is not required. Mr. Didas, Senior Counsel, assisted by Mr. D. Picha, Counsel for the respondent, newly imitated respondent number 6, and Mr. K. Talukdar, Counsel for newly imitated respondent number 7 are present. Next, the learned counsel for the learned senior counsel for the petitioner submits that an amended writ petition has been filed.
Yes.
My lord, yes. So the said amended writ petition is not on record. Next, the registry shall tag the amended writ petition on record. Next, pending the amended writ petition to come on board, let a notice be issued on the newly imputed respondent numbers. Sorry, to the
Number 5.
Respondent numbers 1, 2, and 3, as well as newly imputed respondent numbers 4 to 7, which is made returnable on 3/6/2024.
Notices have already been issued, my lord.
I don't know. There's no order. We are just that's why we are sending to you. There's no order.
I think only can serve to my learned friend Mr. Dotto. He's appearing for Asher.
But if he's
No,
not
I'm just telling. He's appearing for Asher in that case. So that part again that gets delayed.
No, I don't know, Mr. Das. The problem is that if I am not finding an order, you see this record.
What goal order?
115.
Oh, one order.
No, what is this?
I had an extra copy, my lord, just for
No. We have to have this receipt
my lord.
copy.
That will again submit because I had taken steps, my lord. The postal also have inquired. It has not yet arrived.
Where is the order?
On the 1st of May.
No. You see, I'm not saying that you are.
My lord.
But here is the record. It's showing that record also. But
no, I understand, my lord. That
no, we must set it right. Records.
No, because
any problem with the records will cause a lot of problems.
No, we'll file a fresh copy, my lord. No problem. We'll file a fresh copy.
No. In the IA, is there any order allowing you to take steps?
Yes, my lord. There was there.
Just check it out. I don't know.
Okay, नहीं वो रेट पिटिशन में है रेट पिटिशन का फाइल उसमें 115 उसमें है
115 I have just given you. You return it back. There is no order here. No, because I have a bad habit of looking at the order. It's past order, then pass a fresh order. Good to see young Mr. Das.
There's some kind of one file must be there because they everything is there. Somewhere misplaced. Is there any other file? No. There's no file.
Because I know very well. When it was moved, the entire file is because I was there.
It's okay. Next picture. At this juncture, the learned counsel for the learned instructing counsel for the petitioner submitted that
Second copy.
just check out this orders will make some difficulties, huh? It's a true copy of the order here. But still notice has not been issued. No, yes, my lord. What had happened, my lord? Only to number 5 we had taken that registered post, and rest to no, without issuance of notice, you see, you can't take steps, mal. Because that time on that day, Dasar had
That's okay,
appeared,
I don't know,
and we
but-
had given it by hand.
No, that's okay. But formal issues of what is the next period.
Whether in the read petition, any order is there, my lord.
No, everything
In the
is
read
okay.
petition, any order is
But
there, my lord.
formal order to issue notice is not there. Has to be there, otherwise you can't take up the matter.
It can be in the read petition also, my lord. Not in the IA, my lord. IA has been disposed of. So,
But this order, find out this order and keep it here, huh? Just flag it. Otherwise, again, there will be difficulty. This order. Please find out the original order and then tag it somewhere. You get it and file it here. Or with the approval of the registrar, you file a true copy here, saying that it is missing. Next paragraph, maybe mention that the order dated 29/4/2024 is not available in the first file. So, however, true copy of the said order is available in the second file. First of the registry shall place the copy of order dated 29/4/2024 in the record of the first file. Notice issued. Notice is made returnable on 3. So the petitioner, the learned instructing counsel of the petitioner shall take fresh steps for service of notice on respondent number 5 by registered post with AD. Only on number 5, madam? Only no. Steps is only on 5. Others are there. Also, in addition, steps can also be taken by through courier service. Next, the instructing counsel of the petitioner is divided to collect the postal receipt number and submit postal track report prior to the Dusty.
Yes.
Again, it has to be if routed through. I'll courier it directly.
I know.
No, because
No, if it's taken by courier, courier will give a.
Dusty is the my learned friend is appearing. That's the whole box. Surely Dutta is appearing for us.
No, but he can't accept. We can't ask a lawyer to accept.
No, I'm not saying that.
We had already taken steps, my lord. I have checked in the postal department. Courier. Collect the postal receipt number and courier receipt number and submit postal track report prior to the next date of receipt. List on Interim
3/6/2024.
interim order may continue.
Interim order passed at this stands extended to the next date of listing, notwithstanding the
connected interlocutory application file.
My lord, one small prayer, my name may be reflected, my lord, along with senior counsel, Mr. Jain, sir.
Okay. The next part, the registry shall reflect the name of Mr. A.K. Saiwala as counsel for the petitioner while listing the matter next.
My lord.
Okay. Third one, three, 6, and the other one is 35. Others should be adjourned.
25.
Huh?
And for the respondent,
20?
25.
25, okay. 25, both sides are represented. Due to paucity of time, the matter could not be taken up today. Next one is agreed to by both sides, list on 30520. Pardon me? It's okay, they'll pass it on. This is item 20. Yes, 27 was brought by mention.
My lord, resolution number 35, this matter may be withdrawn, my lord. I would like to withdraw. Since the petitioner is not willing to pursue the matter.
Okay. Your name?
N. Tanya.
N?
Tanya. Madam Tanya. They have been recently engaged me to withdraw that.
You've been engaged? But
Yes,
your name is not recorded here.
Morning, I have filed my bakalat.
When did you file it?
Yes.
When did you file your vakalatama?
Today itself. In the morning, my lord.
Everything is your vakalatama is not there.
My lord, I have filed, my lord.
Let's come there after tomorrow. Your vakalatama is not there. This is also counsel for the your name, please again.
N. Tanya.
Tanya, counsel for the learned counsel who submits that he is filed his vakalatama in the matter. He has instructions that the petitioner is not willing to pursue the matter. Next paragraph. However, the vakalatama filed by the petitioner, filed by the learned counsel is not on record. List on, give a day after tomorrow. List on 22/5/2024. The registry shall tag the vakalatama of the petitioner's new counsel on record. You see, we have difficulties. We may not allow your prayer at all, even on 22nd. Let your vakalatama come first, then we will say. We'll have to adjourn it now. When do you want? When do you want?
26.
On which date you want?
24th of June.
24th of June. Okay. Both sides are represented. Due to paucity of time, the matter could not be taken up today. It is agreed to by both sides. List on 24/6/2024. Yes, Mr. No. Okay. I've seen you after a long time. Your health is okay. Okay. I've seen you after a long time. That's why. Okay. We keep it here only. Because tomorrow this matter is listed again. Mr. PJ Sega's matter. Let it remain here. Don't remove this.